5.
I call to order the regular meeting of the Lakewood City Council of October 14th, 2013. Will the clerk please call the roll?
Murphy?
Here.
Ellen? Here. Wickman? Here. Quinn?
Here.
King? Wilson?
Here.
Barraway?
Here.
Johnson?
Here.
Hall? Here. Coop?
Here.
Royball?
Here.
You have a quorum.
Thank you. And as always, I'd like to welcome everyone to Council Chambers and thank you for taking part in your local government, either by being here tonight or watching us at home on television or live or archived on our website. I would ask now that we all, first ask everyone in Chambers to silence any cell phones, anything like that they might have going. And now I'd ask everyone to rise for the Pledge of Allegiance and please remain standing for a moment of silent prayer. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Please be seated. Well, the next, I'm going to ask the clerk to read the next item into the record and just say, we do proclamations here from time to time, and they're all special in their own way. But tonight we get a chance to focus and pay attention on a great community asset run by just wonderful people serving the youth of Jefferson County and the Denver metro area, and that's the Gold Crown Foundation. So I would ask Margie to read it into the record and then ask Fran and everyone to come on down. I'll meet you at the podium.
Item 4, proclamation, Gold Crown Fieldhouse. Yeah, please. Okay, I would ask Mayor Pro Tem Wilson to read the proclamation.
Proclamation recognizing the 10th anniversary of the Gold Crown Fieldhouse. Whereas the concept for the Gold Crown Fieldhouse started with the goal of providing basketball programs for girls and replacing vanishing middle school sports programs, and whereas the Fieldhouse redeveloped the former site of the football field for the closed Alameda Junior High School with a facility that includes classrooms, a concession area, and 6 basketball courts that can be used for a variety of indoor sports and community and fundraising events. And whereas today the Fieldhouse provides services to children that extend far beyond sports and includes art and technology enrichment programs, the computer clubhouse, a community garden, family potlucks, festivals, and many other programs. And whereas the Fieldhouse is part of the Gold Crown Foundation's facilities in Lakewood that include the Coca-Cola All-Star Park at Kelly McGregor Field. These facilities now serve more than 35,000 children each year. And whereas the grand opening of the Fieldhouse occurred on October 19, 2003, with Colorado Governor Bill Owens and baseball legend Cal Ripken in attendance. Performance artist Danny Dent also painted 3 giant portraits, and the U.S. women's national volleyball team gave an exhibition during the grand opening. And whereas the Fieldhouse is a $6 million first-class indoor sports, education, and meeting facility serving multiple needs in the community. Now, therefore, be it resolved on behalf of the City Council and the people of the City of Lakewood, Colorado, I, Bob Murphy, Mayor of the City of Lakewood, Colorado, by virtue of the authority vested in me, do recognize the 10th anniversary of the Gold Crown Fieldhouse in the City of Lakewood, given under my hand and seal of the City of Lakewood this 14th day of October 2013. Bob Murphy, Mayor.
I can't overemphasize how important Gold Crown is to the community. You started out, as I recall, with about 150 kids 10 years ago. And those programs that started with basketball and volleyball and so on have evolved to golf and lacrosse and those very important art and technology and classroom programs as well. So, summer camps, you hosted the National Wheelchair Basketball Championships. We're all over for that. You've expanded into the disabled athletic community. So it's with great, great pleasure that I present this to Kevin Petty the executive director on behalf of the Gold Crown Foundation. Kevin, thank you.
Thank you, Mayor. I brought with me a few of our team members tonight. Adrian Collier, who is the director of our after-school clubhouse, Ms. Fran Baker, who heads up our enrichment and education programs, and Mr. Kobe Cheney, who heads up all of our sponsorship and development. On behalf of these guys and Ray Baker and Bill Hanslick, our co-founders, I certainly like to thank Mayor Murphy, City of Lakewood, members of City Council, City Manager Ms. Hodgson, and certainly the Alameda Gateway Association Executive Director George Valek. We've done a lot there in 10 years. It's amazing. Some of the things that we're proud to be able to say that we've done. We've hosted more than 4 million families and kids in our facility. We've provided over 200,000 opportunities for youth, and the facility remains just a shining example of the success that can come from a partnership. And in our case, the partnership remains strong. City of Lakewood, Jeffco Public Schools, and Jefferson County Open Space. So on behalf of all these guys and everybody at Gold Crown, thank you for your support, past, present, and future, and we look forward to many more years of serving kids and families in the community in Lakewood. Thanks.
Thank you.
Mr. Mayor.
Thank you very much.
Thank you so much.
Thank you, Mr. Valek, for helping to put that together. It was very special. Will the clerk please read item 5 into the record?
Item 5, presentation, citizen commendations.
I would ask our police chief, Kevin Paletta, to come down.
Thank you, Mayor Murphy, members of City Council, Kevin Paletta, Police Chief. Is Donnie Panarello in the audience tonight? Would you please come forward, Donnie? This is certainly a very pleasurable time for us to recognize citizens in our community. As we know, we depend very greatly on the citizens of Lakewood, and frequently the citizens go above and beyond what we expect. And tonight we have the privilege of recognizing 2 such citizens. Donnie, on March 19th, shortly after 11 a.m., you stopped at a vacant property on Yarrow Street in response to a for sale sign posted in the yard. While viewing the property, you noticed a van backed up to the house in the driveway, but you saw no one nearby. As you walked around the property and knocked on the door, nobody answered. As you were returning to your car, you noticed that there was a hose coming from the exhaust pipe of the van into the interior. Coming closer, you could see that there was a woman lying unconscious in the seat. Without your cell phone, you ran to your vehicle and flagged down Sergeant George Hinkle of the Lakewood Police Department, who followed you back to the van. When you arrived, Mr. Panarello immediately entered the van, turned off the ignition, and opened the doors to ventilate the vehicle. You did so with complete disregard for your own safety, fully aware that the buildup of carbon monoxide inside the vehicle might be at a toxic level. Mr. Panarello, it is my belief that your actions to flag down a patrol vehicle and quickly ventilate the van greatly contributed to the woman's recovery, and you very possibly saved her life. In recognition of your actions that day, and in support of the citizens of Lakewood and the men and women of the Lakewood Police Department, it is my distinct pleasure to present you with this Chief's commendation, and I thank you. Thank you, Donnie.
Thank you.
How you guys doing?
Good. How are you?
Good. That was pretty intense. No, I got a good family. I got great support. I try to do the right thing. Try to never look the opposite way. I'm trying to raise my kid to be a good citizen, a good human being, and I couldn't imagine just running away from that. So That was the only time in my life I think I've never had my cell phone. And when I went down, I went, really? It's at the Sprint store getting fixed. So I remember pulling in. I seen some officers. I love Lakewood. I came here after Katrina, kind of refugee to Denver, Colorado. Lakewood's been a great place. I try to get into all the communities out here, and I moved to Denver. Lakewood's a little expensive. Y'all got to lower the prices so I can move back. I moved to Denver just right outside. I truly love this area. Come shopping, bring all my family and all my business here. So I couldn't imagine. I really appreciate you guys doing this for me, and thank you.
Thank you. We appreciate you. Thank you.
Also, if I could have Chris Harper come forward. On March 3rd at approximately 4:30 p.m., Colorado Mills security officer Christopher Harper had been on patrol at the Mills lot when he noticed several vehicles on the north side of the 5-story parking structure, which he had initially thought was a traffic accident. Officer Harper responded to the scene to find a woman lying face down on the pavement with major injuries. Without hesitation, Officer Harper turned the woman over and attempted life-saving measures until Lakewood agents and West Metro paramedics arrived on scene. Unfortunately, the life-saving efforts failed to revive the woman who had taken her own life by jumping off of the parking structure. Despite having several anxious witnesses on scene, Officer Harper remained calm, reacted quickly, and retained a professional composure throughout the entire incident. When life-saving efforts were concluded, Officer Harper took it a step further and began speaking to the witnesses on scene and assisted the Lakewood police agents in securing the area. Due to these combined efforts, additional and unnecessary exposure to this trauma was avoided by innocent citizens. Since becoming a member of the Mills security team, Officer Harper has frequently assisted members of the Lakewood Police Department and has proven to be an excellent asset. He continually maintains a positive attitude, is a team player, and respectful of citizens and public servants alike. Chris, this is my distinct pleasure to recognize your courage, professionalism, and willingness to go above and beyond what is expected of a citizen of Lakewood. Therefore, I award you the Chief Citizen Commendation from the Lakewood Police Department, and I thank you. Thank you. Thanks.
I'd just like to say thank you to Lakewood Police, and thank you for all their support and guidance while working at the mall. So thank you.
All right, thanks.
And as I think some people know, Chris is the son of Lakewood Police Sergeant Mitch Harper, and in addition to being a courageous young man, he's also a tremendous golfer.
Really? Can you say ringer? We can have some tournaments maybe next year. Good. Thanks, Chief. You know, it's so great. Sometimes, particularly this time of year, we hear some negative things, and it's just wonderful to remind ourselves from time to time about how great the people that make this community really are. So between Gold Crown Foundation story and the story of those two commendations, it's really wonderful to hear. So thank you again. All right, on to public comment. This is the point in the meeting where the public is invited to address the City Council on items that do not appear on the agenda. All comments should be directed to City Council. I ask that all in attendance observe the decorum of City Council chambers and refrain from applause or audible support or discord with the speaker. With one exception I'm going to mention in a minute here, there is a 3-minute time limit on public comment. And there are indicator lights here. It'll be green for the first 2.5 minutes. When that threshold has been reached, it'll turn yellow to indicate that you have 30 seconds left. And then it'll glow red when the 3 minutes is up, at which time I would ask you to conclude your comments. I believe, Heather, you still want to, you want to go? Pardon me? You are? You want to go third down? You're speaking for the neighborhood. Okay, sure. Gary Hoskins, please. Mr. Hoskins. And Claire Richardson. Okay, sure. Come on down. That's 6. They've signed up twice.
And I have a handout. Can I give that?
Sure, just give it to the clerk. You bet.
I'm actually going to speak first, just because I was one of the ones that experienced the most damage, but I live in the Jewel Ridge Townhomes at 10490 West Jewel Avenue. We had massive flooding on June 6, 2012, and what brought to my concern about it being either an HOA problem or a City of Lakewood problem is that the fire department was called out and said that there was an excessive amount of debris in one of the sewage drains and storm drains near our property. So I had gone back several days later to just investigate the storm drain to see if it was clear, because I had contacted somebody at the City of Lakewood about it. And one of the maintenance mans who said he comes by and inspects the storm drain said that it was clear, there were no problems. So I went by 2 days later, and it was halfway full, and on the other side, opposite side, the north side of Jewel, it was completely dry, so that was telling me it wasn't flooding or flowing the right way. So I then took all of my information, presented it to Siri Southwick, and she reviewed it and said that it wasn't a City of Lakewood issue, it was our HOA issue. So I kind of let it go, and on July 13th of this year, our units flooded again for the same reason. So we've addressed it with our HOA, and they've said that there's a 10-inch storm drain or pipe that runs from our property down into that storm drain, and that's something that we have to approach you guys about in regards to getting it taken care of. And they said that they have done a scope of that drain and found debris, dead animals, and so forth in that drain. So we're just looking for a way of, or finding out how that's going to be handled, if it's something that you guys are going to take care of, or if it falls in your jurisdiction, and as well as if there's reimbursement that can be handled as well. So.
Okay. Gary?
As I understand, our people jetted that, and dead animals and debris were in it. All of us, including the vice president of our HOA, myself, others, have emailed you folks with this problem. As of today, I have not heard any response. And on the email, it said within 10 days, you will hear something. And we're well beyond 10 days. So we were told that the city engineers have come over and looked. They've agreed that it is the City of Lakewood's problem, and that they're going to dig where it floods, where the water gathers, that you're going to dig it deeper, and then you're going to try and get the pipe large enough to make it flow from our side of Jewel over to Smith Reservoir, where it's supposed to drain and carry this water. So my question is, where do we stand at this point, and when can we expect something to be done? Because all of us, when the building flooded the first time, there's 6 units, and we have a common floor, and the walls stand on the common floor. It came from Claire's area, and the other literally pushed the windows out of the basement. She had over 3 feet of water. It flooded into ours. We had about a foot, and then it went through ours like it was like a river standing watching the water flow, and it went into the end units, and they each had over a foot of water. So, we're talking carpet, we're talking drywall, we're talking major expense. Claire had to replace her hot water heater and her furnace. So it isn't something that's going to go away, and we really need to have you folks give us an answer as to when it's going to be taken care of.
Mr. Hoskins and Ms. Richardson, thank you for coming tonight and bringing this to our attention. I'm just judging by the sort of blank looks up here. I'm not sure that any of us got any of those emails, but never we did? Okay. I assure you we will get a response to you. I assure you. Thank you.
Well, and just to let you know, I have been CC'd on these emails, and I was under the impression staff did meet with you, so we'll be following up on that and make sure that they'll get back to you if they haven't done so.
That they met with the HOA, just your engineer, but nobody from
anywhere else? And you haven't been given a timeline or anything like that? Okay.
Right.
We'll
if you could email us that, at least we could let the HOA board know where you're at.
Right. And you're on the sign-in sheet, so we can contact you. Okay. Sorry it's taken so long.
Yep.
Thank you.
Fair enough. Thank you for coming out.
Yeah, I didn't get it.
Okay. Heather? And just by way of explanation, I kind of alluded to this in my instructions. We normally have a 3-minute time limit per speaker. We have, as a matter of practice, when there are agenda items, when an item is on the agenda, we have allowed one person to speak for 10 minutes on behalf of a homeowners association. The 2090 Coalition is not an agenda item, but is clearly an important item, and therefore Heather and I talked this afternoon, and thought it was important enough to grant her that 10 minutes on behalf of the association. So welcome, Heather.
Thank you. Before you start my time, hearing the police officers tonight, I wanted to thank the West Metro Fire Department because they've helped me with my children, actually my youngest, twice now in the last year and a half. So actually last year. So anyways, they've been very, very helpful in very scary circumstances. And so I figured as long as people were thanking our heroes, I would do my share because I keep meaning to write them a letter and haven't. So
thank you. Your clock has not started yet.
Thank you. Okay, so I am now. You can start the clock. I am here tonight on behalf of the HBG Neighborhood and Community Association, 2090 Coalition, neighbors in Green Mountain Village, Green Mountain Village, Heritage West, and Bear Creek Village. And I'd like to wish you and our neighbors and fellow citizens a good evening. 2 weeks ago, we stood before council and asked you once again to consider evidence that we have uncovered regarding the 2090 South Wright Street property. After being roundly dismissed as commoners by Councilwoman Kellen, told that we wanted to pretend 2090 was a park by Councilwoman Barroway, and that we were making vague accusations by Mayor Murphy, we are back tonight to talk to you and the people of Lakewood. There was nothing vague about our claims made at the last meeting. We made 7 very specific points. The most important is about the January 1977 deed. Margie, who's in charge of the overhead? Please. We're there. Thank you. The 1977 deed to the city for the 2090 property. There have been requests for clarification as to why exactly the city's deed, also known as the January 1977 deed, is the winning deed since it is not recorded, and Jefferson County Public Schools deed was recorded. Indeed, this is a legal conundrum and a reason banks insist on title insurance before loaning you money to buy any piece of property. The long legal answer can be found in our motion for summary judgment and expert witness opinion posted in the 9/22/13 legal update found at 2090coalition.com/legal. For those who want a plain English description, here goes. Thanks to the Cornell University Law School. This important excerpt is Race Notice Statutes Legal Definition. Can you make that a little bit bigger, please? And I was a teacher before. Let's see here. A recording act that gives priority of title to the party that records first. but only if the party also lacked notice of prior unrecorded claims on the same property. As an example, Green Mountain Inc. purports to sell a piece of land to the city of Lakewood for $100,000, and the next day purports to sell exactly the same piece of land to Jeffco Public Schools for another $100,000. JPS will own the land only if it was not aware of the prior sale to the city of Lakewood and if JPS actually records its interest before the city of Lakewood does. The key word in this example is and. Two things, therefore, were required for Jefferson County Public Schools deed to deem the 2090 property belonged to the school district and not to the city, according to the race notice statutes. Number one, no knowledge of the prior conveyance of land to the city of Lakewood and recording their deed. Jeffco did record their deed, which fulfills requirement number two, but had notice, as evidenced by the last piece of information, that the district finally turned over to the lawsuit, which means that the city of Lakewood is the owner of the 2090 South Wright Street property. See, this letter is to the Board of County Commissioners, Jefferson County, and it is signed, sincerely yours, Jefferson County School District R1. RPE is Bob or Robert Eckert, who was a planning and facilities person in the school district in 1977. 2090 has been a hotly debated topic for a full 2 years now, starting with the school district vote to surplus the property in October 2011. What the public was not informed of, unless they had been to our website, is about what is contained in these documents. I will briefly note them and have given them to Margie for you to ask if you need to see any of them. Number one, the state's Attorney General's office correspondence with the city. This is one of half a dozen correspondences with the city. It's March 30th, 2012. It's a memorandum from Heidi Deneen of the State of Colorado Office of the Attorney General to Tim Cox, Lakewood City Attorney. It says, quote, "The state and its title company will require such a written assurance or a quit claim deed to clear the cloud on the title." And they're referring to the title for Jefferson County Public Schools. Second piece of evidence, there's several, but two national title companies informed the school district and city of the title issues that the city must resolve. Fidelity National Title Company. So I'd like you to see, actually, this here, that it is from Fidelity National Title Company. States on page 4, letter D under the requirements section. Yep. Sorry, I made you skip. Quit claim deed from the city of Lakewood to extinguish their potential interest by reverter, as disclosed by the regulations and stipulations contained in the planned development map recorded August 3rd, 1973 at reception number 584887. There is another title document from Land Title that says a very similar statement. Here's a sampling, only a sampling, of various employees' correspondence with the city beginning in 1983. In 1983, Ross Williams states, "I find that the intended use," and this is to the school district, "I find that the intended use for these parcels was schools, but if they were not used for schools in 8 years, they were to be parks." Second piece of information from the city's files. September 30th, 1993, Richard Plastino's memo. And go to the next page, please. "Citizens and community resources consider the Wright Street site to be an established and desirable element of the city's park system. Yet it is also clear that if the school site issues are not resolved among the school district, the city, and citizens in the area, there will be some difficult legal problems between the city and R1. For example, if the school district should someday unilaterally decide to use the site for a school, the city would now be forced to respond with some type of court action claiming that it is now a city park under the provisions of the official development plan." The last example I have tonight is certainly The most eye-opening for me, I just discovered this one last night, December, because it was just given to us a week ago, December 6, 2001. We believe this one will be familiar to our own city manager, Ms. Hodgson, tonight. It states, because I believe she was director of the Department of Community at that point in time. I therefore request, on behalf of the city, that the school district relinquish all claims to this site and deed it over to the city. Additional requests from the city to the district occurred no less than 7 other times, with 2 occurring as recently as 2010. We are going to place the original deed back for the public to view while we continue, just because. Ladies and gentlemen of the public, if this is a case of the citizens pretending 2090 is a park, then it is equally true that our very own city has pretended that 2090 is a park for 38 years. As these documents show, multiple city employees, including Kathy Hodgson, appear to believe this as well. Where was all this evidence when the council had a chance to decide whether they would rezone the property? Was the council notified and yet chose to ignore the evidence? Or did employee make mistakes? Why was the January 1977 deed altered after we were in litigation? If you are watching this or here tonight, you need to know that this could happen to you and your neighbors. How many hundreds of thousands of dollars will it take your neighborhood to fight the city? Our mayor informed us at his deposition that the only legal pleading he had read was the city's own motion for summary judgment, a document that is 30 pages long and presents only the city's side. This shows a gross disrespect for the taxpayer funds at stake here. As you can see here, councilors, mayor, and neighbors, the city was deemed to have an interest by 2 national title companies, the state's Attorney General's office, and its own staff. Given that this variety of different parties stated that the city had an interest, it is clear that to us that the city has a viable claim to this property. It should be beyond reasonable dispute that our city government must represent the interest of Lakewood citizens first and foremost. When property to which the city has a claim at stake, When property to which the city has a claim is at stake, city officials have a fiduciary responsibility to protect that property to the benefit of Lakewood citizens. And frankly, any elected official who does not believe that, first and foremost, they should represent Lakewood citizens, should not be in office. Regardless of how the judge decides on this case, the city should have been on the side of its citizens. We thank you for your time.
Thank you, Heather. All right, thanks, everybody. Tom Stocker? Go ahead.
Ladies and gentlemen, my name is Tom Stocker. I'm an attorney. I'm a resident of Lakewood. Have been for, I think, about 38 years now that I think about it. I live just up the hill from 2090 Wright Street. I wasn't aware of this dispute until very recently. And I'm a sole practitioner. I make my own judgments. I don't represent anybody here tonight, but I'm here to give you my opinions on what's going on down there. And I've got a pass out with attachments that will support everything I'm saying. This land was deeded to the city in 1977. Subsequently, it was deeded to the school district, R1. However, the owner, Hutchinson, I call him Hutchinson because I live in a Hutchinson house, couldn't deed it to the school district subsequently because he already deeded it. So he had nothing to deed to the school district. The school district went ahead and recorded the deed. The school district knew of the deed to the city. Also, the ODP provided that the land would be used for a school if it was going to be used for a school within 8 years. So it'd be by about 1985, I think. That didn't happen. So even under that, there's a reverter back to the city, even if it had been deeded to the R1. Under Colorado's race notice statute, that's 3835-108.1, and I've got a copy attached to you there. If you have notice of, and Heather alluded to this, if you have notice of a prior deed, then even if you record after that prior deed, your subsequent recordation is not effective, okay? And that's the position that R1 finds itself in. So for 35 or so years, I think Heather said 38 years, this land was treated as open space. It was posted as open space. I believed it was open space. I went down there a few times, a little bit down the hill from where I am, but it's part of the system of gullies that goes clear up to Green Mountain, behind Dunstan, etc. Sometime around 2012, R1 decided it wanted to use this land, and that's when the fight started. It filed a 105 to quiet title. Lakewood, amazingly, incredibly, filed a disclaimer of interest. I have no idea what authority you had that based that on, but to me, Lakewood should have filed a counterclaim to quiet title in Lakewood's interest, not disclaim interest. By filing a disclaimer, Lakewood conveyed the land to R1. By conveying the land to R1, it violated the city charter, which prohibits a conveyance of land without a vote of the public. So what I'm asking you to do tonight is to do the right thing. Stop this stuff. File this week a revocation of disclaimer and put this litigation to bed. Take back that land. Use it for open space. I've walked it. I spent 2 hours on it a couple days ago. It's a beautiful piece of land. And I would encourage you to do what's right instead of having citizens stepping into your shoes trying to do what's right.
Thank you. Thank you, Mr. Stocker.
I would encourage you to read what I submitted.
Thank you. I wonder if we could, Margie, or somebody move that keyboard that's kind of covering up the light for the benefit of folks that may follow the public comment. Thank you. Donnie Panello?
That was the guy who received the commendation.
Oh, I'm sorry. Anyone else wish to comment on anything that's not on an agenda item? Come on down. If you just state your name and address. This is on a non-agenda item?
Yes.
Okay.
Good evening. My name is Anita Springsteen. I'm an attorney. I live here in Lakewood at 1593 South Newland Street. And it came to my attention last week that there was activity in an empty lot across the street from us. And I started making inquiries about it and found out that construction on a group home is going on across the street from us shortly. Apparently the permits have been issued or are about to be issued. And I know that this is an issue that has come up before and is coming up over and over again in the city because we've been doing a lot of research about what's been going on. And frankly, we have a lot of concerns about why all of a sudden so many group homes of that nature are popping up in our residential neighborhoods. And in our particular case, this group home is being built from the ground up. It's going to have 10 beds, 12 beds, 10 rooms in it. It's going to encompass 5,000 square feet on the lot, whereas all the rest of the single-family homes on our block and in our neighborhood are 3 times smaller than that. So it's definitely a change in the character of the neighborhood. It's a commercial enterprise. We found out that there are the same contractors are putting another home of the same nature up, I think, on Virginia Avenue. There's a group home that there's been a lot of contention about around the corner from us on West Mexico that apparently has caused emergency services to be dispatched 23 times in 6 months. And so this is a drain on our community, our tax dollars. And we have been told the situation and why the zoning ordinance is supporting the ability of these people to build these type of homes, that it has to do with the Fair Housing Act. We understand that. What we don't understand is why it seems that these things are going up without neighbors knowing anything about it. We did get a letter in the mail a couple days ago from the developer. Just the adjacent properties did. That was very misleading. It said that these people put up single-family homes, and it said nothing about what they're really doing. And so we have a lot of concerns about how this is changing the neighborhood that we all moved into. We moved to Lakewood because there was a country feel to it, and it's changing.
Thank you.
My name is Karen Bushlack, and I wanted to know why. Oh, what?
Hang on just a sec. I want to be fair to you on the time here. There we go. Technology at work. Okay, thanks.
I want to know why the neighborhood, all of the neighborhood, didn't get notified of this building that's going up on a land, the residential land area, because I didn't get notified, and I'm within the 300 feet of the property. And usually when they have a letter get sent out to the adjacent properties are 300 feet, it means a special permit. And with the special permit, it means that you need to notify the neighborhoods so that they know what exactly is going on, so that we can understand exactly what this group home is. Because I know when I purchased my house, a single family just meant one family that lived there. There was no special use for it. And now these other items are falling under it, and in my opinion, the way I translate it is that a special permit use would be used for a group home or for an alcohol anonymous group home, a halfway home, and other items. I think it's a special use permit, and I think that they should follow the procedures of notifying the neighborhoods of the type of development they're going to be making on that land. And I wasn't notified, and quite a few other neighbors weren't notified either. So.
All right, thank you.
Thank you.
If you could just give us your name and address, sir. Welcome.
Yes, my name's Evan Brown. I live at 1593 South Newland Street, across the street from the proposed construction. My concerns principally stems not from the occupants of this property. I understand that under the ADA and the Fair Housing Act that disabled people need a place to live. I'm fine with that. What I'm not okay with is that developers are using the ADA to create a carte blanche for themselves to essentially build what is being touted on the internet as a start your own group home developer kit. You can come in and occupy a residential space. You're protected under the American with Disabilities Act, and you can erect a building that is not consistent with the restrictive covenants of the neighborhood, is not consistent with the character of the neighborhood, is not following the setbacks and the deed restrictions of the neighborhood. I do not believe that the Fair Housing Act entitles a developer to build a property that deviates so dramatically from the other houses in the neighborhood. And I'm just curious what the approval process is for something like this. Who is the entity that approves a project like this? And what are the steps in this process? We did not know about this until we got a letter in the mail that was very, very generic, did not reveal any information of any kind. And it's my understanding that the interpretation of this being a done deal under the ADA, it just doesn't seem to address the concerns of homeowners who have firm entrenched interests in this neighborhood and the character of the neighborhood. And it strikes me as very short-sighted that these permits would be issued to these developers without concerns, without putting restrictions in place, that they adhere to and respect the concerns of surrounding homeowners. I've looked at the plans for this building, and it looks to me like a big giant box they're going to erect. And it's a 5,000 square foot building next to 2,200 square foot homes. And I just can't see how it's going to conform to anything in the neighborhood. And I'm just wanting to see if you're aware of this process. This is a cottage industry across America. If you Google group home on the internet, this is being sold as a package to developers. And you are going to encounter more and more of this. People are taking over residential homes protected by the ADA and basically abrogating homeowner rights in the surrounding homes. And I think it's unfair. And, the interpretation of these laws is still subject to quite a lot of discussion, I think, here. So to say that this is a solved matter, I think, is premature and disrespectful to many homeowners who have obviously entrenched interest in maintaining the character of their neighborhoods.
All right. Thank you.
The largest home is 1,500 square feet in our neighborhoods.
Yeah. Thank you. Anyone else? Public comment? All right, with that, I'll close public comment. I'll just say some folks know I've been at this a long time, between 6 years on the Planning Commission and 8 years on council and 6 years as mayor, and this issue of group homes has always been challenging and sometimes frustrating to neighborhoods. And I know that because I have 5 homes away from me in my neighborhood. So, and as you say, traditionally the interpretation has been that we're governed by the Fair Housing Act, and a group home is treated in the same manner as a single-family home, and they have the same rights to home ownership and a place to live as any one of us do. So, having said that, that was an interesting presentation, and we'll get back to you. We'll follow up on some of those points you brought up, particularly in the close there. And our city attorney is nodding his head, so thank you. All right, that closes public comment. Will the clerk please read item 7 into the record?
Item 7, legal update.
And Mr. Cox.
Good evening, Mr. Mayor and council members. At our last regular meeting, there was, as there was tonight, presentations during public comment regarding the 2090 Wright Street case, but also there were questions from council members about some aspects of the case. We had some discussion offline about how often information had been provided. We have provided memos at various times during this process to the council, but it's been a while. And in light of the status of the case, which I'll talk about in just a minute, we thought this did present a good opportunity to update all of you on the litigation and how we got where we are today, and where it goes from here, which we hope is near the end of the line, but we'll find out soon. This is not intended to respond to or rebut the comments you heard tonight. We didn't know what was going to be said, although we had an idea. And just as the comments made last week, that was not the purpose of this update, but rather to provide council with information so that you have the opportunity to ask questions as appropriate. I did ask our litigation attorney, Pat Wilson, of the law firm of Murray, Dahl, Kiekenmeister, and Renaud, to be here tonight, because when we get to that portion of the update that concerns the case since he got involved and has handled the litigation for us, he's in a better position to provide you with that information. But I'd like to start by first telling you what the next steps in the process are and why we think this is a good time to give you a quick update. The briefing, all the parties in the case, and that would be the Jefferson County R1 School District as the plaintiff, the city as the defendant, and the interveners, the group identified tonight by Ms. Wenger, as well as several individuals as the interveners. Those are the three parties. We'll have an opportunity for oral argument before the court next Monday, a week from today. That's because all the parties have filed motions for summary judgment, and in very brief form, a summary judgment motion essentially says that even if there were no disputes in the material facts, Judge, you should be able to decide this case as a matter of law in our favor. We filed summary judgment, the district has, and so have the interveners. So the court has decided to have this oral argument next week, not an evidentiary hearing, not a trial, but an oral argument for each of the three parties to have an opportunity to explain to the court why its motion should be granted. There is a possibility the judge will rule that day. The last time there was a hearing, the judge did have her order prepared apparently before the hearing, and ruled from the bench. That could happen. The judge could take it under advisement. Whatever happens if the case is not resolved, there is a trial date set for November 4th. I think some, if not all, of the parties believe that the trial won't be necessary, that the summary judgment motion should resolve the dispute, but we'll just have to see. But we are now just 1 week away from the argument on the summary judgment motions. So the briefing's all done. The parties have committed their positions to writing, and now we'll try to persuade the court on their positions. What I wanted to do is just provide the background leading up to Mr. Wilson's involvement, and then let him take it from there. I have dates that have been accumulated from different places, and believe them all to be accurate. If we miss anything, I'm sure someone will let us know. But in terms of formal process, this dispute began really in November of 2011 when the Jefferson County School District filed its pre-planning application with the city. That was the first filing to let the city know that there was a plan to rezone that property. The formal application was filed a few months later in February of 2012. So that's when the rezoning case began in earnest. Neighborhood meetings were held. The Planning Commission heard the case and voted to recommend approval in May of 2012. And in late June of 2012 is when the City Council had its public hearing and rendered a decision approving the rezoning that would ostensibly have rezoned the property from the official development plan, the planned development zoning that was in place, to the R2 zone district. As you all recall, a referendum was filed challenging that rezoning ordinance, and shortly thereafter the Jeffco R1 School District submitted a letter to the City Council asking if you would rescind the approval rather than go to the special election that the referendum would have required. And there were adequate signatures on the referendum petition to get it to election. And on, I believe it was the 10th of September, just over a year ago, that the council voted to rescind that rezoning approval. In the meantime, just about a month earlier than that, in August of 2012, the Jeffco School District filed its quiet title action that Mr. Stocker referred to a few minutes ago as a Rule 105 proceeding. Based on information that had been gathered and reviewed by a real estate practitioner who has advised the city for some 30-plus years on real estate matters, and based on the evidence available to us, the city filed a disclaimer of interest. The document in question at that time was the official development plan, which referred to the property, the 10-acre parcel, being deeded to the city and then to the school district for the construction of a school, and if no school was constructed within 8 years, then back to the city. That's what the official development plan contemplated. As we all now know, the deed that was given to the school district in September of 1977 and accepted and recorded does not refer to the reverter language. It was a straight conveyance without restrictions in the deed itself. And based on that information, we were advised that the city's ability to prove ownership of the property was very much an uphill climb. And based on that, the disclaimer of interest was filed. That being the case, there would have been two parties in the case. The district would have presumably filed a motion for summary judgment and established its right to ownership. What happened next was that the interveners, this group that we referred to earlier, the association, the organization, and the individuals, exercised their option to move to intervene in the case. It's a procedure set up in quiet title actions to allow anyone else in the world who may have a claim of ownership to the property to get into the case and assert that right as against the plaintiff who claims to own it, and in the typical case, the defendant who claims to own it. It's an opportunity for someone else to say, hey, I have this document which gives me the right to own it as well. And the parties present their cases to the judge who rules on that. So the motion to intervene was filed, a couple of hearings were held, and in April of this year, the court ruled to grant the motion to intervene, allowing those individuals and that association into the case. And with that, once allowed to intervene, the interveners, as they're referred to in the case, essentially filed their own complaint, cross-claims and counterclaims, but affirmative claims against the City of Lakewood, against the Jefferson County School District. Just as we had to respond to the district's complaint in quiet title, a default would have entered against the city had we not, we also had an obligation to defend the claims asserted against the city, as did the district, defend the claims asserted against the district by the interveners. I raise that because one of the questions posed at the last meeting was by what form were we authorized to enter into litigation against citizens of Lakewood, and the answer is that claims were asserted against the city of Lakewood, and we were a defendant in the action and had to respond or face a default. Once the interveners were in the case and those claims were asserted, it was no longer a simple quiet title action. That's when we made the decision, as we often do with litigation, to bring in experienced litigation counsel. It's awful difficult to manage the deadlines in a lawsuit when you're dealing with the day-to-day operations of the city. And we have, as you know, a relatively small full-time legal staff here at the city. So litigation counsel was brought in the person of Pat Wilson from the Murray Dahl Law Firm. And Pat has been running the show subject to our direction since that time. And I'd like to invite Pat to come up and fill in the rest of the timeline and tell you what the city's position is at this point.
Thank you, Mr. Cox.
Good evening, members of the council, Mayor. My name is Patrick Wilson. I'm a partner at the law firm of Murray Dahl, Keegan-Meister, and Renault. Our practice is almost exclusively local government. My partners are the city attorneys of Wheat Ridge, Edgewater, a number of other jurisdictions. Thank you. I'm the primary litigator for our firm and do almost exclusively litigation on behalf of cities, counties, and special districts. A lot of that involves condemnation, quiet titles, and lawsuits such as this one. I wanted to give you, Tim asked me just recently to give you a quick update. This is a kind of a critical moment in the case. The trial is set for November 4th, and there is probably going to be a decisive hearing next Monday on the issues in this case. As Tim alluded to, I do believe that this case can be resolved simply on the undisputed documents and the legal arguments and the case law that all the parties have cited to. I don't want to get into too much of our legal thinking on this because I don't want to waive an attorney-client privilege that I have with you all as my client. But I do want to say a couple of things up front that I think are important for you to know. And the first is that if, in my review of this case, if I would have felt that the city had a claim of ownership to this property, it would have been incumbent upon me to come and tell you that. And tell you that through Tim or through Tim Cox or the city manager, that would have been something I would have done. Second of all, I can assure you, based upon my review of the documents and the law in this case, that the city does not have and has not ever had an ownership interest in this property. And I'll explain why in just a moment. I also want to reiterate another thing that Mr. Cox alluded to, and that is that there are no claims asserted by the city against any of the citizens or the neighborhood groups in this case. We are reacting purely in a defensive mode to defend claims that the city has acted illegally, without authority, or otherwise contrary to law. When Mr. Cox filed the disclaimer last August, when the quiet title action was first asserted by the school district, I believe that that action was authorized, not only by the charter, but also by the city's contract with the city attorney. He has an obligation to serve the city's interests in litigation. Not only was he authorized, but I believe he was required to do that. Putting up a claim of ownership in this case, claiming that the city owned the property and fighting with the school district would have been a baseless and frivolous lawsuit and a waste of city money. You have to realize that even if the city had not been brought into this case by the claims asserted by the 2090 coalition, Jefferson County wasn't going to let go of this property. They have the deed to this property, and they weren't going to roll over, and they're not going to roll over. They own this property, and they have since 1977. Tim mentioned the trial coming up and the hearing next week. There was an effort at mediation. The court ordered the parties to go to mediation. The city didn't have much of a role in that, but the school district made some offers to the coalition to design any type of use of that land in a way that might be amenable to them. Setbacks, berms, landscaping, trails, all of those were rejected. So there was an effort on behalf of the parties to try and resolve this. I want to give you just about a 1-minute nutshell to understand this case and why I believe, consistent with David Powell, the city's outside counsel, and consistent with Mr. Cox's own opinion as to why the city doesn't own this. The 1973 official development plan is not a document that creates property rights. It doesn't transfer property rights, and it doesn't create plats or lots. It's a zoning document, and it identified a very vaguely identified 10-acre parcel that was to be conveyed to the city and then subsequently conveyed to the school district for school sites. That didn't happen. What happened was the developer, Green Mountain Inc., attempted to take a bunch of parkland that was supposed to be parkland and the school site and tried to give it to the city all in one deed. And the day after that deed was received by the city rejected it. We said, we can't take land that we're supposed to sell to the school district when it's combined with parkland. That was in your charter now, but back then it was under a state statute. So the city rejected the deed immediately and said, well, there's also some other problems with the deed. Legal description's wrong, the acreage is wrong, a number of other things. Subsequently, the developer came back and split the property out into 2 separate deeds, 10 acres to the school district, remaining 26-point-something acres, which is now Lower Hutchinson Park, to the city. Those deeds were accepted. There's a city resolution accepting that property. The intervener's case would have the court rule that anytime someone wants to get rid of some property or convey some property, they can simply just hand a deed to the city, and the city has to accept it. The law in Colorado is very clear. Dedicated land must be accepted by the government. If that wasn't the case, people could dump all kinds of polluted or contaminated or undesirable property on the city. So the only deed that was ever accepted by the city was one for the 27 acres of Hutchinson Park. And that land is undisputably parkland. The 10 acres was deeded to the school district. School district's board accepted that land. Those are the 2 deeds that were recorded. If you look at the history of documents throughout the 70s, 80s, 90s, and 2000s, all of the memos and the letters that the interveners have alluded to, both here and in the district court litigation, all suggest that the city recognized it didn't own the property. At times, it wanted to acquire the property from the school district. At other times, it didn't. But there was never any indication by the city that the property was owned by it. There was never any claim. The city's been consistent upon that throughout all of the documents that I've looked at. There's an allegation I just want to briefly touch on, that there's been some misdoing, alteration of deeds, and it just infuriates me that people make those kinds of allegations. There are baseless There's no alteration of deeds. There's been no cover-ups, no secret meetings. I've gone through this record, and if there was something that I felt you should know about, I would have told you when I first found out about it. I have fairly high confidence that the court's going to rule that the school district owns the property. Whether or not that's something someone wants or not, it doesn't matter. I think that's the right ruling based upon the historical facts and the law in the state of Colorado. That's really all I have right now.
Thank you, Mr. Wilson. Any questions from council within the obvious parameters that were in here? Councilor Wickman?
During the 38 years, or whatever the math is, since these deeds started back in the 70s, who's been maintaining this property?
From the discovery that's taken place, there hasn't been much maintenance of the property. It's largely open grass. It's not manicured or so it's not irrigated. There is a strip along Wright Street, about the first, I think people said, first 5 to 6 feet of Wright Street, that apparently was mowed. But I believe that the city engineer...
By who?
By the city.
Why would the city be mowing land that's not theirs?
Because, well, actually, the right-of-way for Wright Street extends beyond the curb by about 6 to 8 feet, I believe. So actually, there's a strip of city-owned land along Wright Street that's inside of the curb, so to speak. So, and then the only other area that I think was ever mowed was the area around. There's a children's playground around there, on the parkland, on the city's property, and some of that land just to the south of there may have been mowed either inadvertently or because there was some claim about there were snakes down there and they wanted to cut the brush back, the high weeds back to a certain thing. But other than those two areas along Wright Street and then just immediately south of the playground, I'm not aware of any maintenance being done on the property.
Has the school district done any sort of spending any money on the property in maintenance?
That I don't know.
And why was there an open space sign on the property saying that it belonged to the city?
I've seen the photographs. There were some signs placed along Wright Street. No one's been able to find out when or why those were placed. There was some indication that neighbors were complaining about people dumping like construction debris on the property, and maybe somebody thought that putting those signs up would deter that. But I haven't uncovered anybody who knows when those were put up or under whose authority or why.
Did the school district put any signs on it indicating that that was their property?
I don't believe. The only signs that I've heard of are those blue open space signs that were up for some period of time. There was a sign there's a chained off access road to I guess a head gate for a ditch that's deep in the property. And I don't know if there's a sign on that today or not, or if it's the school districts or the water districts. It's not the cities, though.
Mm-hmm. Councillor Barraway and then Councillor Kellen.
Mr. Wilson, thank you very much for your presentation. And two things. One, does signage and or maintenance define ownership of a property?
Signage or maintenance? No. I think the only reason those are brought up is they're an indication that if the city were to be deemed the owner of the property, they might make an argument that it should be maintained as parks or open space. But it really doesn't. It doesn't overcome the clear and unambiguous history and the deeds in this case, and that's that the property went to the school district.
So if I understand what you said earlier, when the deeds were done back in 1977, that when it was going to be all the parcels, I think 37 acres would have been the total parcel.
Correct.
That the developer was trying to deed over to the city, and the city rejected it because at the time there's a state statute that said they could not accept. Well, if they were to take it all as parkland, they couldn't then sell it back to the school district because the state statute would not have allowed them to do that, and that's the reason why they rejected the original deed.
Right. They would have been required to hold a vote to comply with a vote of the citizens to comply with the ODP. So yes, you're exactly right. They correctly, I think, in my opinion, rejected that deed and asked for it to be broken out into two separate deeds.
So the two separate deeds are the only deeds that have been filed in reference to the either 2090 South Wright Street or the adjoining property around 2090 South Wright Street that would have come from the developer to either the city or R1.
Those are the only ones that were ever recorded with the clerk and recorder's office, which is where you record deeds when you trying to comply with the race notice statute.
You also said earlier that the ODP does not create property rights nor land ownership. Correct.
That's correct. And so it describes what is contemplated or what might be done with the property, but you're right, no property rights are conveyed, created, or transferred by that document.
So it's the deed that's been filed with
That's the bottom line. That's really all there is to it.
Okay. And just back to that ODP, in that reverter clause, it didn't say that what it said, if I can remember this correctly, is that if the school did not build property there, school, that it then would if it were to revert to the city, it would be for municipal purposes.
Right.
It did not say parkland.
Yeah, and other language in that ODP refers specifically to parks and open space. So when they said municipal purposes, they clearly meant something broader than just parks or open space. You're right. That the reverter could not have operated because the city never owned the property to revert back to.
Right. So very clear. Only 2 deeds have been filed.
Correct.
Thank you.
Councilor Kellen?
So just to further clarify, the January 77 deed that was presented to us earlier, is that the deed that was rejected?
Yes, it was, the day after it was received.
Right, and I did, with further examination with my handy-dandy magnifying glass, I do see that it does refer to a 37.7 some acre parcel.
Correct.
Which is larger than what we were talking about. So is there documentation from the city as to the rejection of that deed?
Yeah, there are 2 memos. One, that deed was actually delivered to the city on January 24th, 1977. And the very next day, a memorandum was created by the city land agent, sent to a deputy city attorney saying, this deed cannot be accepted for the reasons I mentioned about it being combined, and also because the acreage was wrong, there were some errors in the legal description, a number of problems that were subsequently corrected by the developer once those subsequent 2 deeds were issued.
Thank you. And just to kind of reemphasize some of what Councilor Barraway said, but my intention to own a land and desire to own a land doesn't really give me ownership of the land, even if I post it with my name on it.
Well, yeah, I think that we'd have a pretty mixed up situation. I think a lot of people want things to be a certain way, but again, as I mentioned, what really drives this and what drives property law in Colorado and everywhere in the civilized world is documents that are notarized and recorded with public recording facilities, and that's what controls the ownership.
And I think we've addressed this before in our conversations, but adverse possession in this situation, that does not apply, or could...
Well, the adverse possession does not run against governmental entities, so it wouldn't run against the school district or the city. The city's not claiming adverse possession, and neither is the Jefferson County School District.
Okay, yeah, because looking at the signs and the stuff and the maintenance of the property, adverse possession would be the only thing it seems to go towards. And if we can't assert that against another government entity, then we don't have a right to that.
That would just be another complete waste of time and resources, and would be a frivolous claim, in my opinion.
Right. Thank you.
Councilor Johnson.
Thank you, Mr. Mayor. Thank you, Mr. Wilson. I appreciate your presentation. For me, very good, honest, decent people have been looking at this in very different ways and coming to different conclusions. For me, again, I think it's very confusing. A lot of the legal language, the conflicting information. It's a tough issue. It has divided a community, and perhaps beyond that community. I am concerned after the trial or whatever happens, that all of us, everybody in this room, we need to look for ways to reach out to that neighborhood, to that community, and find some healing. We've got some very hurt feelings in many directions, in many ways. And I want to see us, after this is over, to move on and to realize Lakewood is a family, and we've got to come together one way or another.
Mr. Wilson, it probably does not call for legal advice, but very well said. Thank you.
Sure.
Mr. Wickman.
I'd like to kind of change the tone here. Like Councilor Johnson says, I appreciate the fact that this is very confusing. I'm obviously not a lawyer, and it's 50-50. But I would like to take a different tack here. As a policymaker, it's not my place to get into the legal details. That's your guys's. But as far as establishing what we as an organization ought to do, it seems to me that our primary fiduciary responsibility is to try to protect the assets of our community. And so, therefore, it seems clear to me that if we have this opportunity, that seems very clear-cut that it is open space land for us, that we should do everything we can to make that happen. And so it seems to me that we ought to be giving you different direction, that we should be directing you to do everything you can to preserve this property in the city's ownership. And procedurally, I don't know how we want to do this, but I would like to say that we would like to direct staff to do whatever we can to take the side of the citizens and try to get clear title to this land and make this a park or open space.
I will obviously do whatever the council as a whole directs me to do, but I can tell you I don't see any basis on which to make that claim or that assertion without violating my rules of the rules of professional conduct and the rules that govern an attorney making groundless and frivolous claims. I just don't see it. I'd be happy to do that if that was the case, but I don't see an avenue that I could do that and making a decent claim or even a claim that had any merit at all on behalf of the city.
So, to staff, if I wanted to make a motion to, as Councilor Stalker suggested, I believe that the terminology was a revocation of the disclaimer of interest. How would we do that procedurally?
Under general business.
Well, it's been the practice of the council for some time that motions on non-agenda items would be dealt with in general business, but the mayor has the option of entertaining a motion at any time.
I'll entertain it right now.
Okay, then I would move for the that we direct staff to file a motion, file the legal appropriate legal language for the revocation of the disclaimer of interest.
Thank you. All right, we have a motion.
Mayor, I'd like to second that.
We have a motion and a second. Go ahead. You got to clear your vote there, or I guess I can clear the vote. There we go.
I just want to say, Councilor Rickman and Councilor Roybal, I know we're going to vote on this, but from my perspective, I understand there are some citizens that really wish that this were open space. But from my perspective, the city taking on the school district and taking land away from a school district isn't in the city's best interest. I love open space as much as anyone, but you don't just swipe other people's land, and especially, really, the school district who, supports our children. For me, that's a tough call, and I understand the people that are close to it really passionately believe this, but if you take a step back, I think there's got to be a lot of people out there that are like, maybe the city shouldn't try to take land from the school district. But, I could be crazy. Thanks.
All right, we have a motion and a second. Councilor Paul?
I just would like Councilor Wickman to clarify his motion. Could you please repeat that?
Okay, the motion is a revocation of our disclaimer of interest. Is that the correct legal language?
Councilor Wickman, it's your motion.
Okay, a move to revocate the disclaimer of interest.
So a yes vote would
revoke our disclaimer of interest.
Okay, thank you.
Quinn and Johnson.
All right, Councilor Quinn. I don't want a lot of debate on this, really.
I just need to clarify
Yeah,
on which
Scott?
vote is yes or no. What does that? I just really want to clarify.
Yeah, I do too. Councilor Wickman, can you repeat the motion?
We direct staff to revoke our disclaimer of interest. With a yes vote would mean we do the revocation.
Is that clear? Mr. Cox?
I think we would be rescinding or revoking or withdrawing our disclaimer of interest if that were the vote of the council. I do just want to point out for the record, procedurally speaking, at our last meeting, there was a suggestion that we have a motion to stop spending money on this lawsuit. That never developed into a motion. I just want to point out that the disclaimer of interest would have allowed the city to state its position and not spend money defending a claim that we did not think we could defend or asserting a claim we did not think we could assert. If we revoke the disclaimer, we'll now become active participants arguing affirmatively for ownership of the land, which would run contrary to the position taken over the last 2 years, and in fact the last 30 years in the memos that Mr. Wilson referred to. We'd be spending significantly more money. We're now, as I said, a week away from the oral argument. The case could be resolved within a matter of weeks, pending any appeals. But the case essentially would start over if the judge would even allow us to revoke or rescind our disclaimer at this late
stage. That's all I need to hear.
Okay. All right. So that's fine. We have a motion and a second. Please cast your votes. And the motion fails. The nays are Murphy, Kellen, Quinn, King, Wilson, Barroway, Johnson, Paul, and Coop. Thank you, Mr. Wilson. The use of the consent agenda has been made to... Do you want to say anything?
Well, I just had a follow-up.
Okay.
And I guess, looking back through our documents, and I would maybe ask for a response from Councilor Wickman or Councilor Roybal. Looking back through our documents, our emails, we've received updates over the last year and a half, periodic updates as to the position we've been taking, where we are in the case. And I'm curious as to why we wait till tonight to take a stand publicly for or against. And I'm just curious, and I'd like to, if I could, hear a response.
Okay, I assume it's directed at me. Well, the answer is obvious. The last couple of meetings, we've had some very good presentations from the citizens group, and I found it compelling. And to ignore it at this point would be unconscionable. As I said, one of my primary values is protecting our open space, and so when the opportunity avails itself, I think we should do that.
All right. All right, no response from Mr. Roybal. Okay. The use of the consent agenda has been made to expedite council action. It contains both resolutions and first reading ordinances. Resolutions are items of a routine nature, and there is one of them on the consent agenda tonight that the public will have an opportunity to comment on in a moment. First reading ordinances, and there are several, 3 if I remember right, on the consent agenda, appear only for the purpose of setting future public hearing dates and ordering the newspaper publication of the proposed ordinance. Therefore, no public comment will be heard this evening on first reading ordinances. The public will have an opportunity to comment on the ordinances, the proposed ordinances, during the scheduled public hearings on the dates set tonight by City Council. Any council member may request the resolution that's on to be removed for a separate discussion under general business. Will the clerk please read the items on the consent agenda into the record?
The consent agenda consists of items 8 through 12 inclusive. Item 8, Resolution 2013-51, updating the City of Lakewood 3-mile plan for annexations. Item 9, Ordinance O 2013-23, approving a cable franchise agreement between the City of Lakewood, Colorado and Comcast of Colorado 9, LLC. Item 10, Ordinance O 2013-24, to rezone land located at 300 South Xenia Way, City of Lakewood, County of Jefferson, State of Colorado. Item 11, Ordinance O 2013-25, extending the temporary moratorium on the licensing, permitting, establishment, or operation of any new business that sells, cultivates, or tests marijuana or manufactures marijuana products, and any marijuana enterprise as defined herein pursuant to Amendment 64 approved by Colorado voters at the November 6, 2012 election and codified at Article 18, Section 16 of the Colorado Constitution and repealing Ordinance O 2013-7. And item 12, accepting the minutes of the Advisory Commission for Inclusive Communities Executive Commission meetings of August 7th and September 4th, 2013, and their full commission meeting of August 21st, 2013.
Thank you. At this time, I'll open the public comment period on the proposed resolution. Under the consent agenda, nobody's indicated a desire to speak by signing up on the roster. Would anyone in chambers wish to speak on the 3 Mile Plan? All right. With that, I will close public comment. I'm ready for a motion on the consent agenda.
Mayor Murphy, I move for approval of the council minutes, for acceptance of the minutes of boards and commissions, order all ordinances introduced on first reading to be published in the Denver Post, with public hearings set for the date included in the ordinance, and for adoption of resolutions, all of which are included in the consent agenda items and introduced into the record by the city clerk.
Second.
All right. Motion and a second on the consent agenda. Any discussion? Please cast your votes. And the consent agenda motion carries unanimously. Will the clerk please read item 13 into the record?
Item 13, Ordinance O 2013-22, adding a new Chapter 54 to Title II of the Lakewood Municipal Code concerning campaign and political finance in municipal elections.
Thank you. Council and the community will recall that we had a study session on this item several weeks ago. That briefing was from Mr. Cox, our city attorney. As you may remember, I appointed a council subcommittee. We began meeting back in February on this topic, and the chair of that committee was Council President Cindy Barraway. And tonight, I would ask, since we've already had the study session, I would ask Cindy to take it from here.
Great.
Ms. Barraway.
Thanks, Mayor. So as you all heard on the September 16th study session from our attorney, Tim Cox, regarding the campaign finance, there are a couple of reasons why we had to take a look at revising our campaign ordinance in the city of Lakewood. And the primary one was because of a Colorado Court of Appeals ruling in 2012 that basically said that laws governing campaign finance can no longer apply to home rule cities that have some type of campaign finance provisions in their city ordinance. So since we already had our own campaign finance ordinance, we had to also deal with if complaints were being filed. If we want to own campaign finance in the city of Lakewood, we need to own all of it. And we needed to take a look at that to put in procedures into place should a complaint be filed, because in the past it would have been sent up to the state, and the state said, nope, no more, it's going to come back to the city. So that was one of the reasons we did it. Secondly, we had some issues that needed to be fine-tuned. Can we clean things up a little bit, put them in a little more organized fashion? And one of the charges we had amongst our committee was to try to keep it simple. As I've stated in the past, the people who run for city council in the city of Lakewood are primarily your average citizen. It's your neighbor, it's your PTA person, somebody running your neighborhood association, just interested citizens who want to get involved in local government. And when you take a look at this document, when you run for city council and you get this packet of information from the clerk's office, you can be quite overwhelmed by it. There's a lot of this and that, and if you do this, you must do that, and if you don't do this, and this is going to happen, and then there's this penalty clause that comes in there, and it's all a little scary and again, overwhelming. And typically the people who are helping you run your campaign are your family and friends. And I'm greeting at Ms. Councilor Johnson because she was just talking about filing her recent campaign expenditure report, and her husband was helping her with it. And so it's average citizens who are running for city council, and we wanted to make sure that when we looked at rewriting this ordinance that we made it as simple as we could, while keeping in place the issues that we need to have in place in any campaign finance ordinance. And over the course, our first meeting was on February 22nd, and we had, I believe it was 7 meetings total on the committee, where Councilor Roybal, Wickman, Wilson, Kellen, the mayor, and myself. I think I got everybody in that. And I believe everybody met was at every one of the meetings. We did have some people from the public attend on a regular basis. We had Kathy Kettner and Charlie Abel attending all of our meetings. We also had Shakti, as well as Doug Anderson was another citizen who attended. And so these were all open meetings to the public. The public was welcome to attend. And with that, you heard some of the things from from Attorney Tim Cox on September 16th about some of the changes. One of them was to put in a system in place so that we could handle our own complaints. We talked about the idea of limits on the city council campaign. So in the history in the city of Lakewood is we have not had limits on how much you can contribute to a candidate for city council, nor limits on what you can contribute to a candidate for the mayoral position. Our group, and I mentioned this at the study session, had a difference of agreement over whether or not we should have limits, and if we were to have limits, what would those limits be? And we came up with a consensus from the group that was involved, even though, again, there was a difference of opinion as to whether or not there should be limits, with the amount of $1,000 per person for somebody who's running for city council position and $2,500 for any one person who's running for the mayoral race. We also talked a little bit about sanctions, about filing things on time, and then we changed the reporting period to something a little bit earlier, to prior to when ballots would actually go out. So that time frame is to the point where now, I can't remember the exact dates, but I know that Margie looked at the calendar to make sure it would work within the limits. I think it was 64 days prior to the ballots going out is when the first reports, correct me if I'm wrong on that one, Margie.
I think it's 64 days prior to the election.
Prior to the election, thank you, that's it. 64 days prior to the election that the first report would have to be filed, and in the past that was closer to actually the election date. So we made some changes there as well. We also talked about limited liability corporations and the issue of whether or not you needed to list who is involved in that limited liability corporation. The committee came up with, if it's $500 or more from a limited liability corporation, then you had to list everybody in that particular corporation. Anything less than that, you just have to list one person from that limited liability corporation, the LLC. And again, there was a lot of discussion on that particular topic. And we mainly just focused on the rules, trying to make them clear, hopefully eliminate some of the gray areas. We recognize that maybe some of the formatting may still be tweaked along the way. It may say a B instead of a D, but for the most part, the content of the and the intent of the ordinance is as you have it here at council and what's been posted on the city's website in terms of the draft ordinance for the campaign finance. I think that pretty much
great job, and thanks, my public thanks to all members of the committee that Councilor Barraway mentioned. This was some tough sledding. This was a lot of things to work through, both in terms of just detail and also the policy implications for the city and for future campaigns. I am going to open the opportunity for public comment, as we do before a motion, and there are a couple of folks that have indicated a desire to speak on this item, and of course anyone is welcome to that didn't sign up. First of all, Charlie, Mr. Abel, come on down. And as Councilor Barraway indicated, Mr. Abel was at every one of the meetings.
Good evening, Mayor and Council. While I appreciate some of the changes that were made, I do find it troubling that your Campaign Finance Committee suggests we lower the bar and cloud transparency when it comes to contributions from LLCs, limited liability corporations. State law requires disclosure of the names and addresses of all LLC members and their attributable share of any donations of any amount, $20, $1,000. For amounts of $100 or more, the disclosure rules are even more complete for LLC members. But you would require no more than the name of one person, even a minor participant at the LLC, or a straw man, for donations of as much as $499. You require complete disclosure from citizens like me who donate as little as $20. Why this change? Maybe because Campaign Finance Committee member Karen Kellen cloaked a 2011 contribution from, quote, CB-LRA by failing to note that CB-LRA is an LLC and failing to disclose, failure to file the required documents disclosing who belongs to the LLC, all of the members, and who the attributable shares were from. It turns out that CB-LRA is an LLC, one that turns out to share an address and a business agent with Continuum Partners, the developer of Belmore and recipient of a generous tax incentive granted by City Council. Or maybe it's because Campaign Finance Committee Chairwoman Cindy Barroway makes her campaign donations through an LLC by her own admission. Or maybe it's because Mayor Murphy had to settle a campaign finance complaint for not filing disclosures on LLC donations as required by the previous law. And he settled by filing that paperwork months too late in order to have the campaign complaint withdrawn by the former city councilwoman who filed it, Edie Bryan. Such self-serving purpose has no place in consideration of a campaign finance ordinance that purports to be fair and transparent. Thank you.
Thanks, Charlie.
I would like, if there's any time left, to yield to Kathy Kentner.
Ms. Kettner is free to have her own 3 minutes when I call upon her. James Bunch. Welcome.
Mayor Murphy and members of the council, my name is James W. Bunch. I just moved here 2 weeks ago, but I've actually had the house here in Lakewood for 3 years. We bought the house in August of 2010, and we just signed up for the Denver Post, and I happened to get that a week ago or so, and this little publication was in there. And I'm an old-fashioned guy, and I still read all the papers, and I read this. And I tell you what, I'm also on a city council. I haven't resigned yet. I'm going to resign the end of October. I still have a house up in Wyoming. So you're probably wondering, what's this guy who hasn't even unpacked his boxes doing down here, concerned about something in the city of Lakewood? And basically, I haven't really read your ordinance, but I read this, and I talked to the young lady who wrote it, and she did a great job. And I thought, well, the bottom line here, I agree with what some of the other council people did, because I've been on these subcommittees and I know how it works. But I do think your contribution limits are way, way too low. I mean, any of you, and you've all run for election, you know who actually pays for your campaign. It's usually the candidate, his family, or his closest friend. And those are the people who contribute. Once in a blue moon, you have this unusual situation that was outlined in the article. And I can tell you that probably at local and county levels, that happens very little. Very little. The bottom line is the individual candidates are out there. They're trying to raise enough money, and it's tough. I mean, if you need name recognition, and you guys, you have an advantage. You're all incumbents. In a way, I don't even know how you guys can vote on this, because it's kind of a conflict of interest, because you're really telling the guy who might be wanting to run against you, hey, you can only put up so much money. And so you kind of have your cabin on the lake, and you're telling him, hey, you're not going to be able to do this. So I really would like you to look at that. I think it's not appropriate. It's a freedom of speech issue, for heaven's sakes. I mean, when you're out campaigning, I suspect nobody runs any ads in the paper because they can't afford them. They probably do it with yard signs. They probably do it with bake sales. Who knows how they do it? But it is very expensive. And quite frankly, those limits, I think, are very, very small. And what you're doing, you're limiting your younger 20, 30-somethings who want to run for office. You're limiting them. I mean, because then I think that's wrong from a freedom of issue. And quite frankly, from a city part, do you guys really want to be involved in campaign finance? I'm surprised that this appeals court would have ruled this. To me, this is clearly an item the Secretary of State should take care of. Your Secretary of State should govern this. This is not a city issue. You guys got annexation, you got enterprise funds you got to run, you've got water and sewer. Well, you don't run your water. I guess you have a regional water thing. But you have enough issues. Do you really want to make your clerk a cop? Is she going to go out there and run these guys down that she thinks are violating this? I think not. And I guess
Mr. Bunch, I'd ask you to wrap up the comments.
Real quick. And I think this whole thing about corporations, it's a legal term. That's how people file their taxes. There's nothing. There's not a pejorative because some corporations involved. That's how people file their taxes. Anyway, I'm just new here, fellow council people, and I wish you'd reconsider the amount. Thank you.
Appreciate you coming out 2 weeks after moving to town. Thank you.
Still went back.
He hasn't resigned yet.
All right. Anyone else wish to speak? Sir? Yeah.
Hi, I'm Gunn Stanson. I'm a candidate in Ward 5 for City Council. So hope to be sitting where you guys are. I'm a citizen, not a commoner. And I just want to say that if any of you, and I understand several of you do, take donations from LLCs, then you should do the right thing and recuse yourself from this vote. I yield my time to Kathy Kintner.
Fine. Kathy, you're welcome to your very own 3 minutes. Come on down.
I think I'm going to take a little more, so that's why
Well, you have 3 minutes. We don't yield. You have 3 minutes. We have 3 minutes, ma'am.
You can talk fast. What? You can talk fast. I can talk fast, and I'm sure if I'm just about wrapping up that you won't interrupt me. Thank you. First, I would like to agree with Councillor Paul, who wrote in favor of transparency. Transparency needs to be the root of this ordinance and not ease for the candidate, as was frequently mentioned at the committee meetings and tonight by the mayor, by Ms. Barroway. I also was a candidate and consider myself common. I don't think the manual is too much to read. Although you all may not have liked Councillor Wickman's contribution to Councillor Roybal, it was quite transparent. Being transparent means we need to make sure this ordinance doesn't create an avenue for anonymous donations. To this end, we should keep in mind the complaint that was filed and settled out of court against the mayor. In this case of the complaint against the mayor, he had contributions from donors such as 8801 LLC, 8805 LLC. Please consider these anonymous donations as you read this ordinance for transparency. And with that in mind, LLCs must be required to list all members of any donation. The mayor also asked during committee meetings that we consider, quote, leveling the playing field. To that end, we must first acknowledge that a truly level playing field does not exist. And as we consider this ordinance, we can create rules that can level the playing field as much as possible. How is the playing field not level? Many of you have pointed out how, without campaign limits, one individual such as Councillor Wickman can influence an election. In Lakewood, however, that's a rarity and not the root of our unlevel playing field. The cause of our unlevel playing field is not what controls the minority, as proven tonight. They have no real influence anyway. The cause of our unlevel playing field is what controls the majority. And what buys control and influence for the majority of our council and mayor are donations from individuals and businesses that are city vendors or have planning cases pending in the city. Well, this ordinance cannot stop such contributions. Tonight would be a proper venue to discuss these donations and whether or not they should be considered conflicts of interest and generally grounds for recusal when these individuals and or their businesses come before the council. Then you can give this direction to your committee. I'm sorry, I was unable to find out who is on the committee doing the policies and procedures, and they can direct it in there. Another thing to consider as you're doing the policies and procedures as it relates to this ordinance is the timing. As you are aware, I tried to find this myself before the study session online, and it wasn't there. Even tonight, I wanted a hard copy, and they weren't back there. It's my understanding that you all received this about 2 hours before the study session. We can't have real, meaningful, deep conversations on ordinances during study sessions if we're only getting them 2 hours. So maybe part of that policies and procedures and discussion tonight can be on how much time do we need to truly study something. Also, we could have done a better job until Councillor Paul's article. None of us had really solicited public comment for this ordinance.
I'm going to ask you to wrap up, Kathy.
Okay. My last thing is actually, I think, just a point of, and this is why I wanted the hard copy. I think I found a little error, but all committee members agreed that the job of the city clerk, kind of goes to what our new Lakewood resident was saying, should not include inspecting the forms for the content. But if you read the very last, and I don't know what page again, under the duties of the clerk, the 6th point, I believe, the first half of it says the city clerk shall, quote, notify any person under their jurisdiction who has failed to fully comply with the provisions of this chapter. I think we had originally intended to cross that out and only have the second part of that says the clerk is to notify any person if a complaint has been filed. But I think everybody agreed that her job is not to go through the reports and check.
Thank you. Right. Thanks, Kathy. Yeah. Anyone else? Come on down.
My name is Chuck Thorman. Mayor Murphy and council members, I'm here to speak in favor of the measure to set a limit on individual contributions to Lakewood City Council and mayoral elections. And I don't think anybody should hide from, no matter what association they're affiliated with, if they do contribute. There's got to be some way to list all those names. It may be difficult to publish them, but with modern day electronics, you can dump more garbage online than you know what to do with. You'll never read all of it. But the city is the base level of politics in our country. And we have too many examples at all levels of government elections where elections are essentially bought by a huge influx of money from a few donors with deep pockets, quite often just before ballots go out. Deep pockets are relative depending on the level of the election. At the national level, it can mean millions of dollars from unions, action groups, or individuals. At our level here in Lakewood, deep pockets implies the ability, at least to me, to contribute tens of thousands of dollars. This is one of the reasons for the need to bring this measure forward. Not the only one, but one. Councilman Weichman gave in excess of $20,000 to Councilman Royball's election campaign. This was an enormous financial advantage over his opponent. We don't know what the results might have been had this not happened, but we do know the vote tally would have been different. At our level of government, we need to focus on the candidate, not on how many signs can be plastered throughout the ward or the city, which in many cases is primarily an indication of how much money has gone into the election pot, not the character of the candidate, nor what the candidate stands for. You can print anything, it doesn't mean much. Please pass this measure in some form close to what it is now, so that in the future more candidates can afford to run and we'll know more about the candidate rather than how much money the candidate or somebody else is willing to put out. The contribution of large sums of money can have the effect of making that candidate in debt to the contributor, and thus feel somewhat obligated to vote in favor of motions that the contributor supports. And one other thing that's bothered me, and I don't know quite how to handle this, but Councilman Weichman, there's a strong rumor spreading through Lakewood that you've been heard to say that you think it would cost you about $100K to become mayor. I certainly hope this is a misunderstanding, so please enlighten us on this, as I find it very distasteful and paint shoes, considering buying the mayor's seat rather than on talent. Thank you.
Thank you. Anyone else in chambers? Heather, come on down.
Bear with me. There we go. Beholden comes in many different forms, and counselors who are getting contributions from special interest groups, construction, outside businesses, that is just as beholden as somebody for an individual, and I'd actually say more so because not exactly sure what one council member might be able to compel another council member to do, whereas construction, I was sitting here listening tonight about the group homes that are moving in, and I just question who the developer is, why they got the permits so easily, why didn't they have to go through the permitting process, and if you have gotten campaign contributions from particularly developers, we definitely have some land use problems here tonight that have been discussed. So special interests, I'd look at the gamut of special interests and go for the transparency of everything.
Thank you. Anyone else? All right, with that, I'll close public comment. I'm ready for a motion.
Mayor Murphy, I move for adoption of the ordinance O 2013-22 on second and final reading.
Second.
All right, motion, second, discussion. Councilor Johnson.
Thank you, Mr. Mayor. First, Margie, I'd like to say if there's any issues with my campaign filing, please consider Walt for jail and not me. Okay.
I don't think you've given me that power in this.
I would like to make two motions to amend this ordinance. The first one is to amend Section 2.54.030 A3 regarding contribution limits, to eliminate the limits for city council and mayoral candidates. And the second motion that I'd like to make is to amend Section 2.54.030 GB regarding LLCs, and to change the limit from $500 to $100.
What page is it?
First, I'd like to say there's been some testimony tonight with some honest, decent people, and I believe that your testimony on both sides has merit, and I appreciate you coming forth. Thank you. First, regarding First, regarding contribution limits, I would just like to speak out a little bit. Candidates, in my opinion, should be allowed to accept any amount of money that they choose. As a candidate, you will be held to the standard of answering to the public why you took the money. Remember, no one is holding a gun to our heads demanding we accept a check. I am concerned that if we have limits, it will leave the city open to litigation. Even if someone has no personal interest in our city, they have standing to sue if they feel there is an issue. And this is based on a case in 1983. Money equals speech. This is a basic tenet of the law. Speech is constitutionally protected. Any limitation of the amount of money a candidate can receive encourages conduct similar to what is going on at the state level in campaigns, i.e., independent expenditures, 501c3s, nonprofits, and my personal favorite, political LLCs. The information that they put out is mostly negative and they disappear after an election. This is what you call hit and run politics. They have no accountability to anyone. They are underground and they mess with our Constitution, in my opinion. They change names and they come and go. There will always be large groups who have money, and we want to encourage them to donate to the individual candidate so that the candidate can do their own messaging and be accountable for what they put out in their own literature. We do not want to encourage others' messaging on our behalf. Restrictions of contributions to candidates puts the power in the hands of special interests. We want to encourage money for candidates to spend on themselves, not encourage special interests, messaging which you may or may not be in your best interest. Local elections should remain local. In my opinion, we are being reflexive over a difficult election cycle. This is not good public policy to base a change on one instance. We have not seen a trend. And finally, as a candidate, if you cannot raise money to have a seat at the table, you will be on someone else's menu. In regards to the LLCs, there's been testimony that I believe has merit. For consistency, we need to have a level of transparency for LLCs similar to that of the donors. Thank you.
All right, thank you. Now, as a point of order, I'm going to repeat the motions. Councillor Johnson has a motion. You may have seen us scrambling up here to find the pages, but the first motion that has to do with contribution limits is on page 8, and that is section 2.54030 A3, right? Okay. So there's a motion to remove, basically to remove that item, remove contribution limits entirely, right? Is there a second for that motion?
Second.
All right, we have a motion and a second. And the second motion was to, and Councillor Barraway helped me find this on page 17.
Do you want to?
I want the item. I want the. Okay. All right. Good suggestion. We're going to do this one at a time. So we have a motion on the floor and a second about. I'm going to turn off the lights here and start over on this one because we have to deal with the amendments before the motion. So we have a motion and a second on removing campaign contribution limits. Comments, please. Councillor Wilson.
You know, I just want to talk about limits a little bit. First of all, I want to thank the committee and council for bringing this to a vote. As most of you know, I'm term limited out, and I really felt involved in this committee and thought it was important that we got something on the books. At our very first meeting, Mayor Murphy said, do we want to do this? Does council want to own campaign finance and campaign rules in Lakewood? And my answer was a resounding yes. And mostly it's because they won't look at problems at the state level anymore. We do have to handle it at the local level. And we've also had some situations that I have found embarrassing when people ask me about them. So that brings us to where we are now. And I think that our document is definitely middle ground, because there are definitely those of us on the committee that felt one way and some felt the other. I mean, we had people that were like, we should follow the state limits, and there are people like Ramey who think we should have no limits. I just wanted to tell you a little bit about my reasoning. Having no limits, people can just give as much money as they want. It doesn't happen very often, but people could buy somebody else's seat, and I'm very uncomfortable with that. On the other hand, There are people who have deep pockets and can spend a lot of money. So how can somebody who doesn't have a lot of personal money compete with them? Well, it kind of leaves you this balance of you have to give yourself enough leeway that you can raise enough money to compete. When I was talking to my ward, at my ward meeting, they were asking about this. I'm like, it's a fine line. People have the right to spend as much money as they want, but if we want it to be anybody in Lakewood to be able to run for office, we at least got to give them the opportunity to raise the money to compete. I even brought up the example of if I had run against Cindy and Cindy decided she just wanted to spend more money, she has more money personally than I do. I would have to go out and ask my grandma, will you give me $1,000? And my parents, would you give me $1,000? Because as much as we like to think local races are so incredibly important, there's really a small minority of people in our city that pay attention to what we're doing. So that's why it's our responsibility as council to hold ourselves accountable, and that's why we're addressing this issue. So for me, the limits that we set were a balance between a free-for-all and being too controlling. So set some limits so that people can still compete, but also hold it so that someone can't just run away with things, because I don't think that's right. So that's my 2 cents. Thanks.
All right. Thank you. I'm going to go to 2 people that were not on the committee, and that's first Councillor Quinn and then Councillor Paul, and then we'll do Councillor Kellen and Councillor Barroway.
Okay. Thank you. Thank you, Mr. Mayor. At the study session a couple of weeks ago, I mentioned that I'm not opposed to campaign contribution limits, only to unreasonable campaign contribution limits. And what I've heard from Councillor Wilson tonight is that the limits that were arrived at were considered to be a balance. But I'm wondering if the committee as a whole had any kind of specific rationale behind the limits that were arrived at of 1,000 for council races, 2,500 for mayor's races.
We looked at the history. We looked at the history of campaigns from 2009 and 2011, and as I stated at the study session, the majority of donations are less than $100. They're $25 to $50 checks that usually your neighbors, your friends, people in your book club write on your behalf. These are the people that know you. There very rarely were there checks of $1,000 or more. In the 2011 election for mayor, the biggest check and the only one was $2,500 to the mayor, and then for city council, $1,000 were the biggest ones that were written out, and that was to even people who won and people who didn't win. $1,000 is about it. But those were very rare circumstances. The majority of the checks, donations, are less than $100 for city council races. Again, it's your neighbors, it's the people you meet, the people that know you that end up writing, or your family members that write you a check. And nobody from my family wrote me $1,000 check, just saying, Diana. So yeah, your grandma was nicer. I don't have any grandmas left, but no, I didn't. Nobody wrote me $1,000 check. I mean, from family members. But anyway, it was a history of the campaign donations.
Okay, I just wanted to know what the specific rationale was, if there was evidence that was looked at, and the history of campaign contributions. That certainly makes sense.
And these seem to be the highest. There were times when in the past where there might have been a higher one for the mayoral race, but not necessarily for the city council race. The only anomaly was the one we've all been talking about, and that's the Wickman-Roybal.
And as happens with committees, this was not unanimous, but it was the consensus compromise of the committee to bring this forward.
Thank you. I appreciate that, Mr. Mayor. And I do not intend to support this motion. There was a reason why campaign contribution limits were created initially. This was a post-Watergate measure to try and curb political corruption in the United States. And I believe it served a very real purpose, and that serves that purpose today as well. And also to level the playing field. Allowing large campaign contributions has the effect of depriving others of their right to free speech. What if I can't give somebody $25,000 or $30,000 in a city council race? That limits my ability to have as much speech as that person who can give $25,000 or $30,000. So for that reason, I will not support the motion. Thank you.
Okay. I said Councillor Paul was not on the committee. So, okay.
Thank you, Mayor. I think I said this before at the study session. The key component to this process is transparency. And when you have an easy way to report and an easy way for the public to see in a timely manner who you've taken money from, I don't believe that there is a reason to have limits. And I support Councillor Johnson and support her amendment to not have limits. You know, in 2007 when I ran, I received a $1,000 check, and if you remember the 2007 election, there was some contentious issues with development, and I chose not to cash that check, and that was a conscious decision because I knew I'd have to answer to the folks who elect me. So I think that system is in place, and I think it's a fair system. Thanks.
Councillor Kellen, Barraway, and then Johnson.
Thank you. Initially, I was just going to say that I agreed with what Councillor Wilson said. Having gone through this discussion, it's a difficult issue for me. I understand the arguments on both sides, and I did argue to have some limits on this. And it's a challenge. I felt like it was important to have a high enough limit that it was reasonable, that it was within the realm of what is the norm within Lakewood. The idea that the money, when you have limits, goes other places and comes in other places. I think at the national level that's probably more true, or maybe at the state level. At the local level, I don't really see that happening that much. And I think I'm ending up, and I've kind of changed my mind 3 or 4 times sitting here already. I will not support the motion on the table because I think philosophically I just think limits make sense.
All right, Councillor Barraway and then Councillor Johnson.
Thank you. I think I've said this before publicly, and I'll say it again, and that is I don't believe in limits. We've been very successful as the city of Lakewood not having had limits within our city, and I believe just as Councillor Paul said, and I have stated before, you are the one who answers to the voters when the voters say, well, why did you accept X dollar sum of money from such and such person who donated to you or an entity that donated to you? You have to be able to answer that and be able to say, give reasons why you did accept that level of money. And then if something comes up down the road, if you're not going to recuse yourself, you need to state specifically why you're not recusing yourself. And I'd like to think that, again, when we have the average people who want to run for city council, that they're out there looking out for the best interests of the city and not for themselves. They're wanting to do something to make the city a better place to be, do no harm, and do the best they can to ensure that the city continues to be a great place to live. And with that type of intention, which I don't want to be Pollyannish about it, but with that type of intention out there, I think that people are going to be transparent about who they're getting money from, why they're taking the money from those people. And it you know, it may be that if I had a grandma out there that had $1,000 and she lived out of state and said, I think Cindy would be a great city councilor, and she wants to send me a check for $1,000 or $2,500, that, boy, she'd really like to have that happen. Yeah, the lights just went out.
Lights just went out.
Outside there, sorry. Yeah. Anyway, I will be supporting this motion on behalf of Rainey.
Okay. Did you want to talk again, Tom? I just didn't turn your light. Oh, you okay? So Councillor Johnson and then Councillor Quinn.
Thank you, Mr. Mayor. Again, I would like to emphasize that no one is holding a gun to our heads to accept a check, and I too turned down a check. $1,000 from R.J. Reynolds because I felt as a nurse I didn't want to accept tobacco money. I want to see us do everything we can to discourage outside entities, the 501c3s, the LLCs. Candidates need to have the money that they need to produce their own messaging. You do not want outside entities putting out information that you can't coordinate with legally. And you don't want them putting out information that you're not comfortable with. Let the candidate do it.
All right. Councillor Quinn, Paul, and Barraway.
I simply do not see how not having, there's a double negative in there, I'm sorry. I don't see how not having campaign contribution limits is going to somehow prevent out of state money or out of city money from coming into our elections. I don't see how it has the effect of doing that. It doesn't make sense. As far as transparency is concerned, by the time the campaign contributions reports are filed, the city's already been smothered in multiple mailings that were purchased with money from those large contributions. So it's highly irrelevant. Nobody's going to pay any attention at that point. The fact is the money has already been spent, essentially, not to buy the election, but to buy influence. They've been able to pay for multiple mailings. other campaign expenditures that swing the election in favor of one candidate. And it doesn't matter whether it's a sitting council member who contributes a large amount of money or it's an outside developer. Either way, there is the potential for corruption, and I think these rational campaign contribution limits help to stem or prevent that problem from occurring in the city. Thank you.
All right. Adam and then Cindy.
Sure,
then
thanks.
We'll close this off.
Councilor Quinn for that statement. But I'd say the money's going to come in either way. So if it comes in at $1,000 or at $5,000, it's going to come in either way. The history has shown that it's very rare that it comes in over that $1,000 mark. And you're right. If you do accept, say, $5,000 from a special interest group, which can be defined in many different ways, it's going to be known, and it's kind of a self-policing, and you're going to have to answer for that. And I think it's been proven in the past election where you saw that money was taken from a developer, a robocall was issued notifying people who didn't know. So I just think that not having limits is the way to go, and I'm going to stand by that.
All right, Cindy?
Sorry, when the lights went off, I kind of lost track of what I was saying. I just wanted to add that having been on the committee, and as I said earlier, we did have some philosophical differences as to whether or not there should be limits and how much those limits should be, if there are going to be limits, and back and forth. I was involved with the consensus to come forward with 1,000 to 2,500. Personally, I do not believe that we need limits, and again, I will be voting in favor of Ramey's motion, but I also want to say that I respect the dialogue and the diversity of thought that we had in that committee to come up with the dollar amounts that we have in this ordinance.
All right, I'll close with my comment. I'm on record as saying I don't like contribution limits. There's a case that was beginning to be argued before the Supreme Court last week, the Supreme Court of the United States. A little different than local politics, but contribution limits are being argued on a First Amendment basis. I do believe that it can unlevel the playing field, and the example of Councilor Wickman and Councilor Roybal has been mentioned many, many times. However, I find myself in the mayoral position here, and I appointed the committee and was a member of the committee, and I'm going to respect the recommendation of the committee and therefore support campaign contribution limits and oppose the motion of Councilor Johnson. All right, so we have, we're going to vote on this amendment first, and I would ask everyone to cast your votes. The motion again is to lift campaign contribution limits. Please cast your votes. A yes would be no limits. A yes vote would be no limits. Let me make sure I get this right. Drum roll. All right, the motion fails 4-7. The nays are Murphy, Kellen, Wickman, Quinn, King, Wilson, and Roybal. Great discussion. Thank you for initiating it, Ramey. Great discussion. I mean, lets everybody know how we think about it. Appreciate it. Now we have a second motion that has to do with the limited liability companies, and under disclosure, paren B, we're saying any limited liability company is authorized to make a contribution which does $500 or more to a candidate committee will affirm in writing, et cetera, et cetera. Your motion was to bring that down to $100.
Correct.
All right. And we have...
I'll second that motion.
We have a second on the motion. I will absolutely support that, by the way. Councilor Wilson?
I have to say, at the committee meeting, we talked about this, and I was the one who proposed 500, or if I didn't propose it, I heavily supported it. And I just want to go on record as saying, you know what, I changed my mind. After looking at the donations that have been given, like Cindy said, the majority of the donations are $25, $50, so there really aren't that many over $100. I do think it's kind of a hassle if you happen to run a business and you're going to be giving out of your LLC. It's a drag to have to, do a board of directors or whatever, but it doesn't happen that often. So I just wanted to say I'm going to support this amendment.
Councilor Koop?
Just wanted the rationale behind the $100 limit. And not $2.50, not $3, not, then why the $100?
I feel personally, I'd like to take it down to 50, but I don't think I have the votes.
Well, what is the rationale for even?
I want transparency.
Okay, isn't there?
You do not have to list all of the people on the LLC until you reach a $500 limit currently. If you take it down to 100, all of the people that are on the LLC will need to be listed, so you know everybody that's bought into that LLC, so to speak.
I'm sorry, I still just don't know the rationale. You don't know if they give $99.
Could I speak to that?
You don't know anybody. You don't know who that is, who everybody is.
Well,
it's just a discussion. I don't understand, and I'm trying to understand.
I want to have increased transparency, Scott, so we know who's putting.
Whoa.
Maybe I'm misunderstanding.
Okay. So we need some clarification here. And Karen asked first, in addition to punching the light first, and then Diana and then Adam. I know you're all trying to follow up on Scott's question, right?
Yes, and I understand. Councillor Johnson would like to have the dollar amount lower. I would not support a lower dollar amount. I feel like the $100 amount is appropriate because it matches with the personal contributions where more information is required. So there's a comparable level there of additional detail required. So for me, that seemed like an appropriate balance.
Okay, I accept that. That makes sense.
All right. All right. Not only did you clarify, you knocked out 2 lights on the board here. That's pretty good. Tom, on this motion?
Thank you. Yes, and I probably will support this, but I want to go back to the work of the committee because I too have a lot of respect for the work that was done in terms of coming up with this provision. Was there any discussion about whether requiring listing of all the members of the LLC for contributions of under $500 somehow imposed an undue burden on the rights of the LLC to contribute money?
That's exactly what it was. So a lot of times LLCs are formed, and somebody made that comment earlier from one of our citizens that came up. They're a way that you run your business. And I had an LLC. I don't have an LLC anymore, but I did. And the reason I wrote my checks out of an LLC is because my husband is a judge. He's not allowed to contribute to political campaigns, and that was a checking account that was separate from any other account that he and I have. And there's no commingling. So that was my opportunity to write a check that I could give to a candidate. Because if I give him cash, then over more than $20, and that causes all sorts of other problems in terms of reporting. So many people who have an LLC, that happens to be they're small business owners, they have the checkbook with them, and they're just ready to write a check. And that's what they were using. So to go back and have to say, all right, so if it's at $500, which is a significant amount, which is because there's very few that are given out, that at that point in time, then you would have to list all of the LLC members. But anything up to $500, you still had to list a contact. So if your LLC is, something like under the Rainbow Bridge LLC, you have no idea who that is or what that might mean. You still had to list the name of somebody as a contact when you filed your donation report to the city clerk's office. At $500 or more, the LLC would be required to file an affirmation that basically says they're going to list everybody that is on that LLC, that is involved with that LLC. So that actually puts the onus back onto the LLC to list who everybody is within that LLC at $500 or more. So if I'm the candidate and I'm accepting that check from the LLC for $500 or more, I need to have them fill out that form as well and give that to me so that when I file it, that affirmation is being filed as well as the record of the donation. Did I state that clearly, Tim?
Okay, thank you. Yeah, I have to confess, I've always been a little uncomfortable with the names on the checks. That I'll have to tell you, during the last, or not this last election, but 2007, I had to look at it and say, who was this? And I hate for citizens to have to do that too. So I think it really is a transparency issue. Thank you.
Okay, so we have a motion and a second and discussion on, and Mr. Cox helped me with this. I want to do this by section here. Section 2.54030.
Correct.
which is on page 7. Then we go all the way to page 18.
16.
17, excuse me. And we're in section G.
3B.
Pardon me?
3B.
3B.
All right, 3B. And the motion and the second and the discussion have been about lowering that number from $500 to $100.
Right. And I would just point out there are 2 locations in that paragraph where the number would change.
Right.
Okay, fair enough. 2 locations. All right, so a yes vote in favor of Councilor Johnson's amendment would lower the threshold there from $500 to $100. Is that clear with everybody? All right. Please cast your votes on the amendment. Nice job, Ramey. Good job. Thank you. We appreciate it.
Mr. Mayor, is it permissible for me to get up and give everybody a hug?
No, it is not. This is an ordinance. Did you want to say anything?
I just wanted to see if I could introduce an amendment.
Sure. Oh, yeah, go ahead.
Since we got through that.
Yep.
As somewhat of a compromise, I know there were 4, but to take a look at 2-54-030 paren 3 contribution limits and increasing those contribution limits for a candidate for council from 1,000 to 5,000 and mayor from 2,500 to 10,000.
I'll second it, just to give you an opportunity to have the conversation.
All right.
And I guess I'll give some rationale behind this. So you heard 3 of us speak, 4 of us speak where we felt on limits. However, there's a lot of good in here, and I do respect the body of work that the committee did. And I think that it's worth offering a compromise, and maybe it's not 5 and 10, maybe it's somewhere in between, but I would like to be able to support this because of what else is in here. So I would offer that.
Thanks, Adam. You know what, man, that's way too high for me. I could do 25 for council and 5 for mayor, but that's half of what you offered up. But that's probably about as high as I could go, and speaking for myself.
Anyone else?
Amy.
Councilor Johnson, and then Councilor Kellen.
Thank you, Mr. Mayor. Thank you, Adam. I appreciate your amendment, and I support it. Thank you.
So the motion on the floor that's been seconded is raise the limits to $5,000 for council and $10,000 for mayor campaigns. Councilor Kellen and then Councilor Quinn.
Yes, I could support higher limits. Either one, actually. So I had thought about higher limits when we had the original discussions and kind of came in around there. I'm probably more comfortable with the 2,500 and 5,000 that Councilor Wilson suggested, but I would probably vote in favor of the larger one as well.
Tom?
I agree. 5,000 and 10,000 is way too high. But I would agree with Councilor Wilson. Would certainly be willing to discuss lower limits, but 5,000 and 10,000 is simply too high. And I think we do have to give respect to the work of the committee in coming up with a balance and looking at the history of campaign contributions in the city as part of their discussion. Thank you.
All right, we have a motion and a second to raise the limits to $5,000 for council elections and $10,000 for mayoral elections. Any further discussion? If not, please cast your votes. Huh. Yeah. All right, so it fails 4-7. The nays are Murphy, Wickman, Quinn, King, Wilson, Barroway, and Roybal. All righty, next motion. 25 and 5. I mean, this is... Or not. It's up to you.
I'll move to amend for 2,500 and 5,000 in the hopes that we get the entire ordinance passed.
I'll second that.
Did you second?
Sue did.
Seconded by Councilor King.
Take a vote.
Call the question.
Huh. All right, so
Are you keeping track?
yeah, I'm going to stick with my original statement, and please cast your votes. Councillor Quinn?
Thank you.
That's
Sorry,
fair.
I should have asked for another minute.
That's all right.
Frankly, I just wasn't prepared to discuss that part of it.
I'm going to clear the votes, and we'll vote again.
My apologies. I'm sorry.
No, that's all right. It's important. Take your time.
Probably over contemplative about this, but thank you. All right.
You ready? All right. Please cast your votes. This is fascinating. All right. And so that motion passes, that amendment passes 9-2, and the nays are Murphy and Wickman.
Will never happen again.
That's a first, Dave.
Never happen again.
Had to call it out. It was there.
Yeah. And
All right.
so,
All right. So now we have any other amendments? Some questions. All right. Councillor Paul.
Just a clarification on, I guess it's in that same section, 2.54-030, number 5, as far as I'm on page 9, paren 5, and this has to do with unexpended contributions. If I'm reading this correct, so you can use this room rental for public meetings, things like that. Cops, community, and council. So if you bought food, does that need to be explicit in?
You know, it really hasn't changed from the last one in that you could use your campaign contributions to give to a nonprofit, to use for your own campaign for something else, or something in support of your job as a counselor. So Cops, Community, and Council, like when I did have some money, I used it to pay for our building where we have our ward meetings, stuff like that. So it's not really a change. It's what we've been able to use it for in the past. And as far as I know, there has been no misuse of funds. You have to report it like you do report everything else, what you spent the money on.
Thank you.
Councillor Roybal and then Councillor Kellen.
Okay, I've been looking at for this, but I can't seem to find it, so maybe I need a little bit of help. There's a section in there, and please help me out. When you accept certain monies and there comes a vote, it's about recusing yourself from that vote if there's a conflict of interest.
I'm not.
That's not in the
not
proposed
in this
ordinance.
campaign ordinance.
That would be something you would do with or without an ordinance. I don't think that was ever discussed at the committee.
No, it was not discussed.
It was briefly discussed because some other cities do it, but we didn't put it in ours. But we also said that counselors are responsible for recusing themselves if they feel like there's a conflict of interest, which we've seen counselors do. But that was the extent of the discussion in my memory, is we mentioned that other cities that do it, we didn't put it in our ordinance, and laid it on the counselor to be responsible to recuse themselves.
Councillor Kellen?
Yeah, just a clarification on Councillor Paul's question. And I think we did change the section on unexpended contributions very slightly. We removed the ability to give contributions to political parties, which was in the state law, and we didn't think that was appropriate because we have nonpartisan elections. So we removed that.
Right. That's correct.
Okay. Adam?
Yeah, and then probably 3 more things. One being, as far as record keeping and e-filing, is there a fiscal note on this, or are you going to need extra money in order to get what you need?
Yes. Let me answer for her.
No. To be honest, we haven't looked into that yet. I've talked to the IT department a little bit. We're not sure if it's something that we can build in-house or not. So we'll be coming back to you with something if we do need it.
And then Ms. Kentner referenced a section that may have been included but shouldn't have been included. Is that?
I didn't.
Yeah, I'm going to, Margie, is it fair to turn to you on that?
Page 19, Margie.
Page 19.
Under enforcement?
Ms. Kettner called me this afternoon, and I talked to Tim Cox, our city attorney, about it. And I think we both feel like number 6 is okay.
Well, I think what we talked about, I don't, Ms. Kentner mentioned that there's discussion about eliminating that first part of the sentence and keeping the second part. I honestly don't remember that, and it could have happened, but and I didn't pick up on it. The intent is that the clerk would not have an obligation to review the substance of reports and determine whether a contribution is in compliance with the ordinance or not. The obligation of the clerk is if you file it late, or it's incomplete, or there's something that's supposed to be on there. So that was the intent. I can see that it could be read to be a broader obligation on the part of the clerk, but it's clearly limited to sort of the procedural, kind of structural aspects of the reports, not the substance of them.
So, is it clear enough?
Well. Some of the things we talked about this afternoon were if it were deemed not clear enough, we could say fully comply with the procedural requirements or the filing requirements, or something that indicates it's the ministerial act of filing the reports on time rather than reporting contributions accurately, because that's not within the.
Can you say administrative?
Administrative provisions.
Administrative provisions of this chapter.
Because, I mean, whether it's an inappropriate donation isn't her business. Somebody would have to bring a complaint. Right. But if they didn't file that they were a candidate and she saw that they could declare themselves a candidate, we kind of are hoping that she'll tell them.
Yeah, and this is something that could probably be fleshed out, too, in the rules and regulations as to the extent of her obligations for enforcement and record keeping. So we could make a change as suggested tonight, or it could be dealt with as Margie gets the rules and regulations in place. They could be addressed there.
Councilor Kellen, did you want to address this question?
Yes. I know we did talk about this issue, and the intention was not to impose undue burdens on the city clerk and to deal with it as we're talking tonight.
Right.
I think under the circumstances, adding additional language, adding administrative procedural, it still doesn't clarify it as much as we could clarify it with the regulations, with the implementation of this. So I think we have a good idea of the sense and the intent of the council of what would be required of the city clerk, and that the best way to deal with it would be to flesh it out where we can do more than just add one word in the ordinance.
That will happen frequently, that the administrative regulations will contain a little more detail than the legislative enactment. So in those rules, it could indicate the clerk's obligations under subsection 6 include the following, and it could be limited to those administrative provisions. But
okay. I mean, this is an ordinance we're passing. I just want to make sure we're comfortable that, that it can be clear to everyone going forward. And if through those procedures everybody's comfortable with that, I am too.
Margie, are you comfortable? I think that's really the question.
I'm very comfortable with it. When I read it, I look at it more, I guess, from a different level, saying that even if there was a complaint, I'm still the middle person. I'm still the one that notifies. Mm-hmm. That I notify the candidate. That's all it says, is I'm the one who notifies it if they haven't fully complied, whether that's not, something simple that I see that needs to be changed, or if it's a complaint to the hearing officer.
Mm-hmm.
All right. Adam and Karen.
Thank you. I just have one more comment. And Mr. Bunch, you brought up an interesting question as to us passing campaign finance on ourselves, and I think there is merit to that. But when we look at passing this, it would have to be staggered. We have staggered seats, so you have some people coming off you have some that could be in office for 4 more years, so you would be trying to figure out how to have the same rules for that whole group. And if potentially, if you enacted it, you could go out 10 years, potentially if somebody were to continue on. So I think that puts us in a tough spot, but I appreciate you bringing that forward.
I think that was Gunnar.
All right. Absent any more amendments or wordsmithing, I think we have a motion and a second. No?
Do I need to restate the motion with the amendments?
The amendments, it should be referenced.
Okay.
The two that were passed become part of the motion to approve.
Thank you.
All right, hang on a minute. Too much paperwork. Aha. I move for the adoption of ordinance O 2013-22 as amended on second and final reading.
Second.
And the amendments are, the contribution limits were raised to $2,500 for council races and $5,000 for mayoral races.
Mm-hmm.
And the benchmark for LLCs was lowered to $100. Those from $500 to $100. Those are the two amendments that passed. So the motion is for the ordinance as so amended, right? Councilor Johnson, did you?
May I just give comment and explain my vote, or is this the time? Or?
Sure.
Okay. First, I'd really like to thank Cindy and your committee. You have done an awesome job. And Cindy, on a personal level, I'd like to thank you. You spent a lot of time with me, talking me through things, and you've supported me. That goes a long way with me. Thank you. This ordinance will pass, as well it should. There's wonderful things in it, and frankly, all of my questions today were answered by Tim. He went through it with me with a fine-tooth comb. Thank you, Tim. This needs to pass, and it will. For me, personally, I cannot support it based on the contribution limits. It is a huge deal for me. I feel I just can't compromise on that one thing, but I'm glad it'll pass, and it will.
All right.
Thank you.
Fair enough. Thank you. Councilor Quinn.
Thank you. The only thing I would like to say is that I believe that this ordinance, as amended, is balanced, based on reason, based on evidence, and I will be supporting it. And I, too, would like to thank the committee for their work. It's important, as many figures throughout history have said, is that politics is the art of compromise. And this ordinance is a great example of that. It's an excellent compromise, and I congratulate the committee and everyone who's worked on this. Thank you.
Thank you. Councilor Barraway? Comment.
Yes, I just wanted to thank the committee once again for all their time. There was a lot of meetings that we had. Some of us had to leave work early to get there on time, and appreciate everybody's input and, again, the dialogue. We had a lot of discussion, which was very good, which is why I believe we ended up where we did tonight, and I appreciate the discussion we had tonight as well. So thank you all very much for that.
All right. Adam?
I would echo that, and thanks to the hard work of the group, and to Ms. Johnson for her work. And I understand where she's at. I don't really know where I'm at. The contribution limit was important to me. However, I do believe something that is broken in politics is the art of compromise, and being able to stay at the table and get something done for the good. And once again, it's not black and white, but there's a lot of good in here. And it goes a long way to say that there was a willingness for give and take, and I think that the citizens will benefit in a increased fashion, I guess, by the passage of this. But I'm still not quite sure where I'm at.
Okay. Councilor Kellen?
Yes. I just want to thank Councilor Barraway for running a ship-shape committee, keeping us all in line there, and moving forward as quickly as we could. But more importantly, I want to thank Councilor Johnson, because what I really appreciate, and I don't agree with you on everything, we didn't agree on the one issue, but I really appreciate that you took the time and the effort to look at the issue and to talk to us, to go around to different people and talk and talk to us about why you think what you do and why you're coming from there. That means so much. I think that's a really important aspect of the work we do. I have an obligation, if I disagree with someone, to try to understand and to tell people why I have this position, not just to sit there and at the last second throw some bomb out there or just drop it on you without ever trying to work the process. So thank you very much for doing that. I think it's a very good example for all of us.
This was a great discussion tonight, a great process all the way through, and we particularly heard tonight from the 5 members of council who were not on this committee and rolling up their sleeves and working for all those months. And that's good. That's good public dialogue, good public debate. I know sometimes there are conversations that you hear once in a while in this community about this council being of one mind, and they all do things as somebody says they should do them. And as you see tonight, that clearly is not the case. So we have a great council, 11 very thoughtful individuals, and I think what you saw tonight is great evidence of that. So I am certainly going to support the ordinance. I will not vote it down based on one particular aspect of the ordinance. I will support it based on the body of work. So with that, I would ask you to please cast your votes on the amended ordinance. And it passes 10-1 with the nay being Councillor Johnson for the reasons she so eloquently stated. All right, any general business?
None.
No?
Nope.
Why am I looking at you? Executive report, Ms. Hodson? All right. Mayor and City Council reports. I would just remind everyone that this is election season, and please do the research. Know your home ward, research the candidates. If you haven't had a chance to read Looking at Lakewood or anything like that, just Google. I mean, there's in this age of the internet, there's multiple ways to find out information about the candidates. So just Google their name if you don't have access to any of that other information. So please do your homework, and encourage you all to vote. Diana, anything?
You know what? I just want to say thanks. This is probably the last important thing that I'll vote on, barring any kind of big thing happening in 2 weeks. So I just wanted to say thank you all. It was important legislation to me, and I'm really happy it passed. So thanks.
Cindy.
On that note, I won't be here in 2 weeks when it's Councillor Wilson's last night on up here at the podium. Sorry? And Councillor King. Both of you are not going to be here. I'm going to miss you both. I'm going to be out of town on business. So if I can do my quick farewells tonight, as opposed to not being able to do them publicly, I'm going to start with Councillor King. Not everybody hears Sue say things, because Sue can be quiet up here on our podium. But Sue has a strong voice, and she does share that, and she does allow us her opinions, and she's done a great job of leading this city over the last 8 years. She's done a lot in her ward that many of you will never know that she was involved in, because she's a quiet voice, but she has a very strong voice. I'm going to miss having you on council, Sue. I hope to see you around. It's been a pleasure serving with you for the last 6 years. On the other hand, we have Diana, who is not a quiet person when it comes to serving on council, and I've appreciated that she states things succinctly, clearly, and to the point, and I think that's going to be missed on our council. What I'm not going to miss, and I don't know if you guys, we've said this before, but for whatever reason, we get confused for each other. In fact, earlier tonight, I think somebody said Councillor Barraway made a comment about the parks. It wasn't me. It was Councillor Wilson 2 weeks ago that made that comment. Not me, but we continue to get confused. But Diana, you have been a pleasure to work with as well. I will miss having you. The two of you, I'm going to miss having on the Head Start governing board. That's a big one. The three of us have been working together for the last 6 years on that, and there are some tough shoes to fill. In fact, I'll probably be calling Diana to find out what to do when they come in and do our study on the Head Start. that, well, because of the federal government shutdown, I don't know if we're going to do it this month or not. But I'm going to miss you both. Thank you very much for your service, your leadership, and for your mentorship over the last 6 years. Thank you.
Thank you. Well said. I don't think Sue likes being the center of attention. We appreciate it, though. All right. Councilor Roybal.
No report.
All right. Councilor Coop. Councilor Paul. Johnson.
None.
Tom.
One very quick announcement, since we still have an audience here, which is rather rare this time of night. And for our viewing audience out there, tomorrow night is the third in a series of 5 open houses on sustainability we're having here at the city. It'll be at 5:30 p.m. here in these chambers and out in the outer area. There'll be presentations, and the focus of tomorrow night's presentation will be on health issues primarily. It'll be a roundtable discussion. It should be good, but that's again from 5:30 to 8 p.m. here in council chambers tomorrow evening. Thank you.
Thank you. Councilor Wickman.
Just a reminder to most of Ward 4, this Saturday, October 19th, is going to be the city cleanup. And it's like say everybody south of Alameda.
Karen.
Yes. Thank you for the city cleanup for the northern part. We got rid of a truckload of stuff. Fortunately, I've had some spare time lately. So I want to let people know that we have the Ward 1 monthly meeting this Saturday, the 19th at 9 a.m. at the 40 West Arts District. That's 1560 Teller Street. And we're hoping to have someone come and talk about the comprehensive and sustainability plans so that people can have a better idea of how these documents are very important to the city, and it's very important for people to get engaged with that. And then just a point of clarification. I'd like to check the record. I don't think I've ever called anyone a commoner. It's just not a word that's in my vocabulary, especially who am I to call anyone a commoner? My God. Anyway, that's all I have.
Okay. Well, technically, I think we all meet the definition of commoners if we are not a royalty, right? So.
That's our resident historian who just spoke. Margie, anything?
Nothing. Thank you.
Tim?
No.
Kathy? All right, we're adjourned at 9:45.